Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3046, United States of America versus Tristan Chandler Stevens, appellants. Ms. Salient for the appellant, Mr. Hill for the appellate.
Ms. Salem, good morning.
Hi, good morning. May it please the court, my name is Megan Salant, and I am here on behalf of Tristan Stevens. Mr. Stevens was sentenced under the incorrect guideline. The lower court relied on the commentary definition of the unambiguous term, the commentary definition of the unambiguous term aggravated assault and switching from the correct guideline 2A2.4 to 2A2.2. The term aggravated assault, as used in the text of the guideline in 2A2.2 and 2A2.4, is unambiguous. Under Kaiser and Stinson, this court should not give deference to the commentary's broader definition. Instead, this court should rely on the plain language and text of the guideline and the definition adopted by 24 states and the District of Columbia, which do not include the term with the intent to commit another felony. This language is missing from the text of the guideline, and it is also missing from the secondary sources cited by the government on page 38 of their answer brief. The plain meaning of aggravated assault does not include intent to commit another felony, and therefore, Mr. Stevens should have been sentenced under 2A2.4. Alternatively, 2A2.2 was improperly applied to Mr. Stevens' case because there was no separate intent between his 111 offenses and his 231 offense. Another felony is defined elsewhere in the guidelines to distinguish between the offense being committed and an additional separate offense. The cross-reference does not say the same intent should be committed, that two offenses with the same intent can be considered.
On your first argument, if we were in a pre-Kaiser world, you would agree that the commentary definition would be controlling here or not?
Well, I think that certainly Stinson requires deference to the commentary, whether the term is ambiguous or unambiguous. But I do think that the way that the commentary is applied here, I think that it is in contrast with the plain meaning of the guideline. I think that 2A2.
So your position is that even in a Stinson world, you would say the commentary's inclusion of intent to commit another felony as a factor, as a basis for triggering the aggravated assault would be foreclosed by the plain language.
Yes, I think that argument can be made. Obviously, I think that Kaiser modified Stinson in a way that makes Kaiser applicable here. But I do think that the text of 2A2.2 gives lots of different factors that increase one's base offense level. And I think that the broad addition under the commentary of the intent to commit any felony seems contrary to that list of factors.
Okay. And then Kaiser applies to agency interpretations of regulation, correct?
Correct.
Okay. But if commentary goes through notice and comment rulemaking, then we wouldn't be in Kaiser world anyhow, correct?
Well, not necessarily. I mean, I think that with Stinson, when Stinson first was issued, one of the reasons that they applied, they discussed in Stinson initially that the commentary didn't go through notice and comment, but then after Stinson, that's never changed. They've never gone back to change their consideration of the guidelines just because now the commentary is considered by Congress.
But it also goes through notice and comment rulemaking.
Correct, I know.
Right.
I'm sorry.
Is there any other area of administrative law where Kaiser is applied to notice and comment rulemaking as opposed to interpretations of regulations?
Not that I'm aware of, Your Honor, but
so your argument is that we should apply Kaiser to decide whether to defer to a notice and comment rulemaking?
Well, the first thing that we do with Kaiser is look at just the term aggravated assault, right? And decide in the normal textual circumstances if that's ambiguous. So, and my argument is that aggravated assault is not ambiguous. And even if it were ambiguous, then we still get to move on to whether or not it's the definition that is created by the.
You don't really have a Kaiser argument here. You're just arguing that the plain language of aggravated assault forecloses interpreting that to include conduct undertaken with the intent to commit another felony. Put aside your separate argument about why you don't have that intent here, but.
I'm sorry, can you repeat that?
So your argument is that this isn't even a Kaiser case. Your argument is that the commentary is inconsistent with the plain language of the guideline itself, full stop. And we can tell from the guideline itself what aggravated assault includes. And so even if we were in, even if it's a notice and comment rulemaking rule that we're analyzing, you would say doesn't matter, plain language of here the guideline, ordinarily a statute, controls. Is that your position?
I believe so. I mean, I certainly, I think that Kaiser applies in the sense that we have to go to the first step, which is the term that we are interpreting ambiguous or not?
Well, you do that under any regulation, whether notice and comment or interpretive.
Right. Correct.
And so you're just stopping there.
Correct.
So because this guideline or this commentary did go through notice and comment rulemaking as well as presentation to Congress.
It did, I believe. I mean, it has. Yes.
Yes. And so it's not just an interpretive regulation. It's the equivalent of a full-blown notice and comment regulation.
Well, but I guess that goes back.
Kaiser never applies.
I guess I do think that Kaiser, I think that Stinson applies to the commentary when Stinson, the Supreme Court has not told us that Stinson no longer applies to the commentary because it's now subject to notice and comment. And I believe that Kaiser applies to Stinson. So yes, although the commentary,
Did Kaiser say it was changing anything in Stinson?
well, I think that it included it in its footnote regarding
That
whether or
doesn't
not.
mean here's something we've done. It's not overruling a prior, that's not how they overruled their prior precedent.
Well, I don't think that they've overruled it. I just think that I mean, the language in Kaiser said that they were restating the Seminole Rock deference and also re-emphasizing its limits. And certainly.
They were talking there about interpretation of a regulation, not a notice and comment regulation, an agency interpretation.
Correct, but yes, that's true.
This is just a different world.
I'm sorry?
This is just a totally different world.
Well, it may be, but I encourage this court to side with the other, not side, that's a horrible word. I encourage the court to use the reasoning that's used by many of the other Circuit Court of Appeals that do find that Kaiser modified Stinson.
I'm a little bit puzzled by why you're struggling against Judge Millett's characterization. I mean, your argument is a textual argument that aggravated assault is clearly and unambiguously excluding an assault with an intent to commit another felony.
I don't know that I think it's excluding it. I think that it doesn't.
It's not defined to
include every single
refer
felony,
to
right?
An assault that is committed with intent to commit another felony. And on your second argument that the two are really not separate felonies at all, even if we accept your rule that the same conduct and intent can't be used to establish both the assault and the other felony, even under that rule, doesn't the government point to separate intent to engage in civil disorder, for example, in the second felony, the 231? You don't need to show any intent to engage in civil disorder to commit an assault against a line of officers or not.
No, but the 111 offense is a general intent offense. So it's just both of them just require the intent to resist or to act.
To do the act.
Right.
So one of the assaults is the actions. Well, there are three. The Stevens's aggression against the officers, and then the 231 is all of those repeated actions in concert with the mob of people trying to overcome the officer's ability to guard the Capitol. That seems like that's, even on your view, which would say, look at the facts, there's a different set of facts that are supporting the 231, no?
Yes, I guess the mob element is there, and that's not present in the 111.
And they're trying to overcome their ability to guard the Capitol. I mean, you could think of other assaults on an officer, retaliatory assault on an officer, or just a anti-police assault. This one has a kind of operative context that is quite distinct from the ordinary assault of an officer.
Sure, but I still think that the intent in committing the 111 offenses was the same. I mean, Mr. Stevens didn't show up to the Capitol by himself to resist or obstruct the officers. He showed up with a group to do that. And so there's no intent that makes it just a 111 offense. That makes sense.
Except that if somebody were, trying to cross across the Capitol during this period, not realizing what was going on, and was startled by an officer and assaulted them, I mean, that would be a very different, isolated.
Sure, absolutely. But that's not the circumstances that we have here.
And can you do a little bit more about, to explain, you rely on Judge Amy Berman Jackson's reasoning in the Hamner case.
Mm-hmm.
She declined to treat a January 6th defendant's conviction for violating 231 as an aggravated assault, to which 2A 2.2 applies. But she, as I read that bench ruling, she is explicitly distinguishing a case like this one, where the base offense level is set by the 111A conviction, and then the 231A3 serves as the other felony. Can you explain how you nonetheless take support from her reasoning in Hamner?
Well, her reasoning was that the commentary doesn't say a separate intent or a separate offense. I'm sorry, that the commentary requires an additional felony. And that's not, again, Mr. Stevens's actions were all one action.
But she specifically, and I'm looking at pages 14 to 15 of the sentencing transcript, she says, we're not using the 231 offense as another felony for the 111 offense in that case, in Hamner. We're going the other way. And that was what she found to be problematic. So she found a case like this one, she was saying that wouldn't be problematic. What I'm finding problematic, she says, is the 231 is the base offense and the 111 is the other felony.
Right. I guess I'm not sure that there's a distinction. There were facts in Mr. Stevens's case that took his 111A offense to make it not the highest, but sort of the middle ground, the exaggerated, he made contact, that kind of thing. So I don't know that makes the Hamner case different. I understand what she's saying about the 231. I understand the question about 231, her statement about 231 not being able to use the 111, but I feel like we're doing the same thing here. It's just that it's grouping. So whether it's one or the other, because in the PSR, the government chose to apply 2A 2.4 to 231 as well. So it was all in one group. So I don't know that it's distinguishable from there. All right.
Just real quickly, why isn't it that your whole argument sort of harmless error here? Because the district court said, I'm not even applying the guideline commentary.
Correct.
I'm under 3553. This is the sentence, full stop. Even if you win on your guidelines argument, this is the sentence.
Right. So as far as harmless error goes, the judge, in making that statement, the judge said he wasn't relying on the commentary. I'm sorry, that he wasn't relying on the commentary definition, but then he cited to Black's, the definition in Black's law. And I think I actually think that the Black's law definition supports our argument. It talks about pardon me, I can't remember the exact language, but the language, the definition in Black's makes it seem as though, like many other states have done, an aggravated assault can be an assault with intent to commit, and then murder, rape. I can't think of another example but those examples. And so although he said he wasn't relying on the commentary, what he is relying on is something that we believe actually supports our position. Because it references another felony, but not in a way of any felony, another felony that would be specific.
I guess I'm still trying to get to the harmless. So you think that?
Oh, I'm sorry.
So
So
he doesn't know, he didn't really mean what he said.
well, I think that he didn't, the way he justified it is contradictory.
It backs into
Right.
commentary by referencing Black's Law Dictionary.
Right, correct.
Okay. All right.
All right. Thank you very much.
Oh, I
give
have
you
one
a
more,
couple-
I'm sorry.
That's
I have
okay.
one more question about the government's use of a kind of Blockberger analysis to say whether something's another felony and whether you had any response to that framework.
Well, I don't think that, I don't believe that obviously it's not a Blockberger test because Blockberger doesn't apply to the guidelines. But no,
By
that's,
analogy, that kind of reasoning.
yeah, I don't, I'm sorry.
We'll give you a couple minutes to reply.
Okay, thank you.
Mr. Hill?
Thank you. May it please the court, Dietrich Hill on behalf of the United States. Tristan Stevens violently assaulted officers as part of the mob during the attack on the United States Capitol. When he did so, he also had the intent to commit civil disorder. That was aggravated assault, and the district court correctly applied the aggravated assault guideline. At the threshold, the commentary definition does govern. The meaning of aggravated assault is at least ambiguous here, and you can see that just by looking to Black's Law Dictionary. In addition to the fact that of all the other sources, almost every source has a different definition of aggravated assault, including all of the state laws cited by Stevens here. And then the commentary definition is at least reasonable. Again, looking to Black's Law Dictionary, as well as the fact that the very structure of the guidelines, including its treatment of Section 113A2, general federal assault with intent to commit another felony, which goes to the aggravated assault guideline. That shows that the guidelines themselves arguably require this definition. Under that definition, Stevens's assaults were aggravated assaults. They involved an intent to commit another felony, 231. The plain meaning of another felony here is a felony with different elements. And there's no dispute, Stevens does not dispute that these felonies had entirely different elements. The key.
You said in your brief that sentencing looks to conduct, not elements. That's what sentencing is about, as opposed to conviction. And so it seems that you're flipping that around now when you say, for purposes of applying the analysis as to what counts as another felony, we should look at elements rather than conduct.
We suggest that you should look at elements just for purposes of determining the meaning of another felony, and then real conduct to determine whether another felony occurred. I mean,
I understand what that means, because that would give you, one can imagine a situation, and they say this is one, where maybe Blockberger would give you one answer on elements, but this was the same conduct, just being counted twice.
well,
You can't sort of say, let's do elements and then let's do conduct. I mean, they can contradictory answers.
I guess there could be a situation in which they give you contradictory answers. This is not that situation.
Okay, but what would happen if you had contradictory answers?
We think that the elements test at least explains the meaning of another felony. So yes, if they gave contradictory answers, the elements
What
test.
possible evidence is there that that's what the guidelines, that the Sentencing Commission meant when it said another felony, as opposed to the natural common sense meaning other felony conduct?
Well, it's not clear And so first we looked at plain.
No, I know, but I'm asking why you're importing elements in as a framework for analysis here when it doesn't, by your own brief, elements analysis doesn't apply at the sentencing stage to the guidelines. Are there other guidelines where they do a element by element analysis, like a Blackburger analysis that you can
Well,
refer us to?
I would point out, and it's a little bit different, but the other thing in the guidelines that supports this analysis is the firearm possession guideline that we cite in our brief, where the commission specifically changed the commentary to make clear that even very closely related possession offenses, such as state law burglary that primarily involves possession of the firearm, should be treated as another felony offense because they have a different element. I guess you could say different conduct too, but that would be the primary support in the
Okay, but then
guidelines.
there's no language like that by the commission here.
No,
So doesn't that suggest the commission had a different meaning here?
I would argue that there was no circuit split over the meaning of this another felony. There was a circuit split over the meaning of another felony offense,
Mhm.
which led the commission to clarify that. And the commission's clarification should also point to what it.
Are there other
here.
circuits that agree with your Blockberger reading of another felony test?
I haven't seen any circuit case directly on
There's-
point here.
Right, so the commission may well have had its natural meaning, like it does everywhere else in the guidelines, unless it says otherwise, of looking at conduct, not elements.
I mean, fair enough, but we also certainly win because there's different conduct here. And the key distinction would be between the intents required for these two different offenses. The assault offense requires a very general intent, at most an intent to injure, but that includes just an offense of
But
touching.
even in that description, you're going back to the legal requirements. Can you give us your answer in more factual terms? Because I think that's what
Sure,
the question, that's how I understood this questioning to be proceeding. If you're, and I understand Stevens's counsel to be saying the on the ground conduct is the same, and the inferences that the court drew in terms of meeting one legal set of elements versus another may differ, but if we're looking for sentencing purposes of the conduct,
the
tell us how
conduct,
there's different.
well, the conduct is the same, but the intent is very different. The intent is a specific intent.
Isn't intent also proved, at least in a case like this, circumstantially by conduct? So if you could, again, tell us.
Dr. Morales-Gelsey?
So sorry. What? Yes, I am coming to my appointment. Yeah, tell us what the district judge would have looked to as an evidentiary matter that would be different on the 231.
I mean, I agree that the conduct is the same, Your Honor. The district court was thinking about the fact that there are two different intents, and particularly that the same conduct is really directed at two different harms here. There's the 111, which is about an officer's physical safety. That's what the Supreme Court made clear in the United States v. Fiola. You don't have to know that there's an officer. You don't have to have any intent to impede. Section 231A3 is at heart an obstruction statute. It's about protecting officers' ability to do their duty during a civil disorder, such as the riot here, to be able to defend the Capitol. And so Stevens was doing two things, albeit with the same conduct. He was both physically attacking the officer, and he had the larger purpose of trying to prevent that officer or those officers from doing their duty during a riot. That's aggravated assault, both in the most technical definition and in the larger definition, because it's assault accompanied by something that makes it more severe than your ordinary assault, for example, during resisting arrest. And the circumstances here, of course, were especially uniquely dangerous. This was a massive riot, and the fact that so many people were doing what Stevens was doing, committing a 111, accompanied by the 231, the specific intent to prevent those officers from performing their obligations, is what made this so dangerous beyond an ordinary 111. And that's what district courts have agreed in hundreds of these cases.
Why do you agree that the conduct is the same under 111 and 231? 231 requires that you act during a civil disorder. 111 doesn't. So why did you, I thought you just said to Judge Pillard, you agree the conduct is the same.
Well, in the narrowest sense that the particular assault on the officer was also the act with the purpose.
For example, 231 requires a nexus to commerce and it requires, civil disorder.
Right.
And you could have a 111. I mean, it's maybe one way of thinking about it is there's an overlap between some of the actions, but the lens of relevance of what conduct you're looking at, the narrative is very different for the two.
Yes, the narrative is very different. And that's the fact that there is a civil disorder going on.
Doesn't matter for the 111.
It doesn't matter for the 111. That's right.
The fact of a nexus to commerce doesn't matter for the 111.
That's right. And that is why committing the harms simultaneously is so different than just the 111, because the civil disorder, because you're preventing the officer from performing his or her duties during the civil disorder.
So what is it that you are conceding when you say the conduct is the same? I find that a little bit confusing.
Just that the same physical part of the attack, in other words, with Sergeant Gannell, the pressing of the riot shield to try to crush his face, that was the same, both the act to obstruct him, Sergeant Gannell, and the act that is assaulting, resisting, opposing, impeding, etc.
But there's also for 231, the conduct of being in a crowd, being in the tunnel, trying to get to the doorway of the Capitol, being aware that the police are setting up a line to try to protect the Capitol. That's a lot of fact that isn't the same.
That's right. And in a broader sense, that is different conduct. And I think that also goes to the different intent as well. When you know that you are in the middle of a civil disorder and you're committing this assault, that's worse than when you're committing an assault on the sidewalk, some kind of retaliatory assault or just spur of the moment.
Can I ask about your harmless error argument? And that is, I understand the aspects of the district court decision on which you rely, but as Counsel for Mr. Stevens just said, the district court did sort of back into the commentary by referencing Blacks and its inclusion of assaults with intent to commit another felony. And, it's a pretty powerful presumption that if there was an error in applying the guideline that is the starting point for the sentencing discussion, that if an error is found there on appeal, this is just obviously a hypothetical question, but if an error is found there, then isn't the best thing to do to send it back so the district court can think again in light of the right guideline?
2 points, Your Honor. First, in terms of using Blacks as an alternative basis than the guideline commentary, the district court looked to the broadest definition where it's circumstances that make it more severe and looked to all of these points, the ongoing civil disorder, and not just the fact that Blacks includes intent to commit another felony. But more broadly to harmless error, the district court made very clear that it was relying on 3553A factors, such as respect to the law, lack of remorse, need for just punishment, as well as factors that are more specific, but that the guidelines did not account for, including the number of officers affected and the uniquely dangerous situation at the Capitol on January 6th.
No, I understand. It's not, the question here isn't whether the same sentence could result. The question really is, given that we live in a world in which the guideline is the starting point of discussion, and if the starting line changes materially, like 50% here, isn't the better course to let the district court, with that information in hand, revisit the sentencing decision? It's a much, much bigger variance. It's a dramatically larger variance, at which point the court might want to think about, wow, in what circumstances do courts make variances of this magnitude? And the stuff that district court just didn't have to think about given the starting point of the guideline that was chosen.
I do think the test, as I understand it, is whether remand would likely be futile. And the district court was so clear here, indeed explicitly said that even if Stevens's counsel were right on every aspect of the guidelines, he would vary to reach the same ultimate conclusion on the sentence. I can't think of a case in which remand would appear more futile.
I guess I hear you and I appreciate that, but I guess the two sort of uncertainties that leaves me with. One is that the cases that the government cites, the Kaufman and Thompson cases, are cases in which the change, the differential still would fall within the guidelines range. So, and here we have something that is actually in both cases would be outside, or in the case that of Judge McFadden's actual sentence is a variance. But also it assumes that a district judge, that the confronting the actual applicable guideline doesn't affect the district judge's reasoning. And I guess the shorthand way of putting it is, if we were to hold this error harmless, then wouldn't we have to so hold every time a district judge says, and I would come to the same conclusion no matter what, all the district judges would have to do to insulate their sentencing, their guidelines errors from review is just say, I'm wrong about that, I would reach the same result. And we have a lot of, I mean, that would undercut Molina Martinez, it would undercut Gall and Rita and a lot of cases.
On the first point, Your Honor, that's right, that they were both within guidelines changes. I haven't seen any case like this. So there's nothing to contradict the more general principle that if remand is futile, then affirmance is appropriate. With respect to what the district judges might say, I think this court can look to the specificity and clarity of the alternate reasons for giving the same sentence. If a district court said nothing but I would give the same sentence, that might get a different level of review than a situation here where the district court goes through many specific reasons as to which he is varying and would vary in the face of exactly the guidelines that Stevens' counsel was proposing. The district court was clearly disturbed by what he called the frenzied efforts, the contempt and aggression shown by Stevens. I think just looking at the video here it's disturbing every time to see Stevens' actions. And the district court clearly was disturbed by Stevens' lack of remorse as well. Essentially no apology and a list of excuses at sentencing. So I don't think the district court could have been more clear than that he would give the same sentence on remand.
In terms of Judge Berman Jackson's analysis in Hamner, I mean, there is I guess it's a little bit unclear from her bench ruling why which one you choose as the initial felony and which one you choose as the another felony should make a difference. I mean, if in this case the government had said the 231 is the initial and then the 111 was the another, do you run into the same circularity? Or I guess it doesn't work that way, but
I think in that case the district judge was especially thrown off by the fact that it was a single 231 plea. There was no plea to a 111. And she felt that there was an excessive amount of circularity in going back to the 111 and then back to the 231.
if we were to agree with her, can you help me understand why that wouldn't require us to hold the same here?
I do think it's different when you have the 111 as the offense of conviction first, because there's no requirement to go from the 231 back to the 111 to find the assault, and then from the 111 back to the 231 looking at intent to commit another felony. That seems like a different situation. So having the 111 first makes it clear that there is a felonious assault involving, and then you looked through the list of the commentary definition and see, yes, there was an intent to commit the 231 added on to the 111. You're not looking at the 231 and using that for every step of the process.
Just one other question, because you have a lot more familiarity with this than I do. Have you seen variances before? I mean, the variance here using the court's chosen sentencing guidelines starting point was up 9 months from the top. And here it would be more than double the top. Have you seen variances that much before?
Not in my personal experience, I can't think of one. I have
Or read
seen,
cases where you've seen it?
Off the top of my head, I can't think of the name, but I have seen circuit cases from other circuits affirming variances that were as much as twice or more the guideline sentence. That would be in unusual cases, but I think this is an unusual case for the reasons identified by the district court.
Thanks.
All right,
And
thank you, counsel.
Thank you.
Ms. Salant, why don't you take 2 minutes?
Thank you. I'd just like to address the point that Judge Millett was just making about the variance. If the court had applied what we are arguing is the correct guideline, 2A2.4, then the variant, essentially what's happening here is that we're claiming, if we are going to claim that there was if the court were to find that there was harmless error, that would be finding that the explanation for a 9-month variance is the same as the explanation for a 36-month variance. And Mr. Stevens, we would argue that that just cannot be found harmless. That's a huge difference. And so we would ask that this court remand for resentencing under 2A2.4. Thank you.
Case number 23-5178. Katherine Daniela Pacheco Quiros et al., Gulshan Karimova, appellant, versus Molly Amador, Deputy Consul General and Visa Unit Chief, U.S. Embassy in Costa Rica et al. Mr. Piston for the appellant, Ms. Ryan for the appellees.
Mr. Piston, good morning.
Good morning, Your Honor. Michael Piston upon behalf of the appellant, Gushin Karamova. This court needs to answer today a very easy question. Is the mere fact that a visa application was refused 3 years ago sufficient reason in itself to dismiss a mandamus complaint? It's easy because this court already answered it in Mashpee, where it said that the ultimate issue, as in all such cases, will be whether the time the BIA is taking to act upon the Mashpee's petition satisfies the rule of reason. That issue cannot be decided in the abstract by reference to some number of years, but will be dependent upon the complexity of the task at hand, the significance and permanence of the outcome, and the resources available to the agency. But the lower court did exactly what Mashpee said not to do. It decided the issue of whether the delay in this matter was unreasonable simply on the fact that the case had been pending for 3 years and didn't take into consideration any of the other factors which Mashpee referred to. In fact, she couldn't take into consideration any of these factors because there was no evidence or even allegations in the record as to what it was. So in doing so, we should compare this case to that of the Fourth Circuit's decision in Gonzalez versus Cusinelli. In Gonzalez versus Cusinelli, the Fourth Circuit looked at a record which was much more developed than the record here. And they still found that the government had not sufficiently satisfied them, that even though they were claimed to be applying a first in, first out method, they hadn't satisfied them that it was sufficient to establish that they were really following a rule of reason. And therefore they remanded the case back to the district court. Here we have a case where the consul didn't even claim to be following a rule of reason, any rule of reason. There's simply nothing in the record whatsoever to say how visa applications are being adjudicated in Georgia. Rather, the judge just simply said, pending 3 years, that's reasonable to me, case dismissed. Now, the government tried to...
In this case, Ms. Karamova has had a meeting with the council, a hearing with the council.
Yes, she
And
did.
her application was refused.
Yes,
They acted on it. They said it's refused, quote, denied, equivalent of denied.
Well, it was,
And then they said, you know, we keep it open for administrative processing, but she has a decision. So it's not as though, I understand your point if they still hadn't even had her in for an interview and made a decision, but they've made a decision. They've just said, for whatever reason, internally or externally, we're not slamming the case shut, but she's had a decision.
virtually every DC district court that has considered that argument has rejected it. Because a 221G refusal is clearly not a final refusal.
How do we know it's clearly not a final refusal? How do we know that?
Well, because because for specifically in Karamova's case, it said, this is not a final refusal and we're going to be looking at your case further.
Well, if the Foreign Affairs Manual is quite explicit that a refusal is a refusal, it's a denial, and it remains a denial, and there's nothing pending, even if they're doing administrative processing. Administrative processing is sort of whatever they wish to do internally. But your client applied, your client got a meeting with the consul, and then your client got a decision that says you are refused, you are denied. And whatever they want to do on their own end afterwards doesn't seem to me to implicate.
Your Honor, Section 5 USC 555B requires that an administrative agency bring to a final conclusion a matter presented to it in a reasonable time.
As far as Ms. Karamova's concerned,
It's not the.
they've got a final conclusion.
Well, certainly the district court in I don't know how many was it, 11 Iraqis seeking justice versus Kerry disagreed, and they said this is clearly not a final decision. And every court that's followed that's decided the case after 5 Iraqis, I don't know if it's 5 or a different number, they all agreed.
We're not bound by how district courts rule. We get to decide this de novo. And so I'm trying to ask you to reason not from, if there's a particular reason in the district court decision you find persuasive, but your complaint was filed because she hadn't even had an interview. There's nothing in your complaint that addresses post-denial administrative processing. And so I'm trying to understand what the argument is that if they have a procedure, an internal procedure that says we're always getting updated information, where we may choose to relook at this again if we get information that seems relevant to us. But as of now, you're denied. The manual says denied means denied. You don't have a pending application anymore. You have a final decision on your application. What are we supposed to do with that?
A denial, which clearly is not a final conclusion of the matter, does not satisfy the requirements of the APA. This denial was clearly not a final conclusion. As you look at our brief.
You didn't amend your complaint after she had her interview and her denial. Your complaint has no allegations at all about this post-denial delay that you're challenging.
Because it didn't really make any difference. We're not asking for a nominal denial. We're asking for a final conclusion.
Okay, well, but if the State Department says it's not a nominal denial, it is in fact a flat denial. But it's to your client's benefit that we will keep the file open in case we obtain information that makes us change our mind. That's something entirely to your client's benefit. But there's nothing else that addresses that they have. There's no regulation that I'm aware of that you've brought to our attention. There's no factual allegations in your complaint about any legal right to a conclusion of administrative processing.
Quite the contrary. 555B says that they have a right to a final conclusion. And this clearly was not a final conclusion because at this
point, all they've said is, we'll keep the file open in case we learn of anything that helps your client. How does that help your client to cut that process off?
The NVC specifically said this is not a final decision and we're going to be reviewing your case more.
It also specifically said that it was refusing the application. I have a prior question about your legal claim. The complaint cites as the basis of the obligation to act, the Administrative Procedures Act 555, but as I read the Supreme Court's decision in Norton versus the Utah Wilderness Alliance, you have to have a specific ground for the obligation to act. And I don't take that to be finding the APA provision sufficient. And you haven't identified any more specific legal duty on the part of the consul to act.
Well, take a look at the court's decision in Mashpee, Your Honor.
I agree. I think the court's decision in Mashpee cites only to 555, and I find that puzzling for the same reason.
You find it puzzling?
I find it puzzling. It predates.
But is it
Supreme
not
Court's-
binding upon this court?
Well, it predates the Supreme Court's decision in Norton, which builds, I think, further a requirement of specific, pointing to a specific obligation. And my assumption is that in Mashpee, everybody understood Bureau of Indian Affairs has a process and an obligation for ruling on tribal requests for recognition. But you're right, oddly, the case is briefed and decided only under 555.
And I would
But
submit to you.
once Norton has now sort of built on that and explained that there's a need for identifying a discrete agency action that the agency is required to take.
And the
555
administrative-
doesn't do that.
The Administrative Procedure Act states very clearly that an agency is required to bring a matter brought before it to a final conclusion in a reasonable time. That is a discrete action. That's what this court ruled in Mashpee. And I submit that that ruling is binding upon this panel. I don't believe the Supreme Court decision reversed Mashpee.
But you know, if I went to the consulate in Georgia and I said, I submitted something and I said, here's my matter, you should change your processing for the, an employment visa to X, Y, and Z, like that would, under your reasoning, be a matter brought before it under 555. But what I take Norton to be focusing on is that you have to bring a matter on which the agency has a requirement to act. And 555 itself does not create that requirement. It has to, otherwise it would cover my, presentation to the consul in Georgia of a proposal that people with a last names that begin with K should be processed first.
Well,
They don't have
respect.
any requirement to act on that, notwithstanding 555.
Well, with respect, Your Honor, I think you're raising a different issue, and that is the definition of what a matter is. And you may well be correct that the hypothetical that you provided would not fall within the APA's definition of a matter. But I don't think there's any dispute that a visa application is a matter. And it certainly is not unreasonable to ask that it be decided brought to a final conclusion in a reasonable time, just as this court ruled in Mashpee that the probably far more complex question of whether or not a tribe should be recognized should be brought to a final conclusion in a reasonable time as well. And I suggest that this court should follow Mashpee. But if this court has determined that Mashpee is in error, I think that probably the best thing to do would be to recommend this case for a hearing and dying.
No, I'm not saying that it's an error. I'm just saying that the Norton versus Southern Utah Wilderness Alliance further elaborates what's required. And that's a Supreme Court case that comes after.
I'm sorry, I didn't hear you. I'm sorry.
The Supreme Court decision in Norton versus Southern Utah Wilderness Alliance comes after Mashpee and further elaborates what is required, which is that the claimant identify a non-discretionary duty, a specific duty on which the agency is required to act, a discrete agency action that the agency is required to take.
And I just don't see how bringing a matter to a final conclusion is not a discrete agency action.
Well, so would it be in my hypothetical, but I don't want to beat a dead horse. It would be a discrete agency action to say that everybody whose last name begins with K gets put at the front of the line. But I don't have an underlying legal claim to that. And that's what I think the Norton versus Southern Utah Wilderness Alliance is focusing on.
I think we're both beating dead horses here because I continue to maintain that the APA does provide a discrete action. This is what this court ruled in Mashpee, and I do not see the Supreme Court's decision as overruling it.
I'll just ask you a quick fact question. When did she learn that her application had been refused?
When did I learn her
Did
application?
she learn, or you learn, well, however it works, that her application had been refused after her consular interview?
Honestly speaking, I really can't recall. This complaint was filed with quite a few cases were all filed together. The government was settling them all, and then at the very last moment, they said, well, we're not going to settle Caribou.
Well, at the time you filed the complaint, were you aware that her application, she'd had an interview and been refused?
To be perfectly frank with you, Your Honor, I would just have to say that what I knew is what I wrote in the complaint, and I really cannot,
Which would then
speaking
indicate
now, or
you didn't
elaborate
know.
upon it.
Okay, so then that did not address or disclose or identify that any action had been taken on her application, and you actually started with the 2019 date there. So I'm to assume that you weren't aware at that point that she had had an interview and been refused? Because you start the time.
I'm really not sure whether or not she had an interview. What I do know is that she didn't receive a visa, and she did not receive what 5 Iraqis considered to be a final refusal.
I have one other fact question, which is in the joint appendix at page 88, there's an email exchange between Ms. Karamova and the embassy, in which she says, my attorney submit that she had an interview and that since then she's provided all requested forms and documents the embassy asked. And I wonder if there's anything in the record or any knowledge as to when that happened, when the supplemental information was given.
I'm sorry, I really can't elaborate beyond that, and incidentally, that attorney wasn't me. See, she had her own attorney for consular processing. I was only brought in for the mandamus. So when you compare this case to Gonzalez versus Cuccinelli, the major difference between this case and Gonzalez is how much better a case the government had in Gonzalez. They said, well, at least in Gonzalez, you have provided some evidence that you were following a first in, first out methodology, and even some exceptions. But what you've given us is not sufficient for us to determine that this is actually a rule of reason. Here, the consul gave absolutely nothing as to how they were adjudicating visas or administrative processing.
All right, Mr. Piston, we have your argument. Thank you.
Okay, thank you very much, Your Honor.
Ms. Ryan.
Good morning, Your Honors. Erin Ryan for the government. When reviewing a visa, the State Department has only 2 options: to issue or refuse it. And after a review of her application and an interview, Ms. Karamova's visa was refused. She had that refusal in January of 2020, 3 months after she filed her application. What she's seeking now is a re-adjudication, which she is not entitled to under the law, claiming that a decision on that re-adjudication is unreasonably delayed. But she points to nothing that says that the State Department has a duty to give her that re-adjudication. And as the Supreme Court held in Norton, a delay cannot be unreasonable if the action itself is not required. Now, while this is styled as a suit seeking mandamus, Ms. Karamova is actually asking this court to decide whether the consular officer can continue to withhold the visa based on the initial refusal, or if they must make another adjudication. And such a review is barred by the doctrine of consular non-reviewability. If the court does reach the merits of the claim of unreasonable delay and a review of the track factors, the district court's decision should be affirmed. Ms. Karamova's pleading failed to state a plausible claim for unreasonable delay. She has not shown that any of the track factors fall in her favor. None of her arguments trying to undermine the district court's decision carry any weight. I welcome any questions that the court may
What is the
have.
status? So after denial, when they say denial asterisk, actually, we're going to keep it here for administrative processing. We'll get back to you. If there are only 2 options, are refuse or deny, what is that status? This
So-
limbo.
Yes, so the visa was refused, but the State Department voluntarily may put an applicant into administrative processing. It's an additional voluntary process the State Department can undertake if they believe there might be additional information that could assist the applicant in meeting their burden.
So it means denial-ish?
No, Your Honor, it is a final denial.
It's not a final denial if they've said, but hang on, we think there might be some information that's going to help you and we might change our minds. That's the reason you put in administrative processing.
I think a way of thinking of it, Your Honor, is to compare it to district court proceedings. If a district court were to dismiss a plaintiff's case on a motion to dismiss, for example, just because that plaintiff can then appeal or seek re-adjudication or reconsideration, no one would say that the district court's decision is not a final decision or that it doesn't have any effect, just
Once
because,
a Rule 59 motion is filed, it's actually not appealable.
Your Honor, the visa.
Not final.
But no one would say that the district court decision is an interim decision because it may be later reconsidered or that it doesn't have any
Jurisdiction
effect.
funds.
Court, if the district court said, well, I'm going to deny your motion for summary judgment, but I'm not sure that I have all the information of record, so actually I'm going to keep it open and accept any information you may have, and then, you know, within due time after I have that information, I'll give you a final result. I'm not sure that we would treat that as a final decision.
That is not what happened here, Your Honor. She was told, you did not meet your burden to prove you were eligible. Your visa is refused. However, you will be given another attempt. And typically administrative processing is when there is additional information outside of the applicant's control that might be needed. For example, if there are security concerns, if an investigation needs to take place from another agency, if there are other information, we want people to come to this country for diplomatic reasons. We give them another chance, but it's not required under the law that we give them that second chance.
That sounds very reasonable, but it also doesn't sound like what the record reflects the agency said. We reviewed our consular records and found that the case has been refused under INA Section 221G, and it is pending the completion of administrative processing in order to verify qualifications for this visa. A decision on this case cannot be made until the consular section finishes its review. Visa applications are adjudicated in accordance with the provisions of the INA. We cannot predict when the adjudication of the application will be completed. Much more of that narrative sounds like we're not done, we're thinking about it, we can't make a decision, we're aware of your concerns, and we'll let you know when we're done.
And I think for the administrative processing, it is open. She is still in administrative processing, but there's nothing under the law, the statutes, the regulation that require them to take this second look. No email or form response from the embassy can create a legal duty where there is none already in the statutes or the law.
But it just sounds like it's a big wink when they say you will refuse or deny, or you will grant or deny. You have two options. That's how you started. And you go, deny, but we don't really mean it yet. We don't know if we really mean it. It sounds like you're creating a third option.
No,
And so
Your
if
Honor.
there are three options on the table, then we don't know yet actually which one is her final answer.
The final answer is that her visa was refused. She
Then
cannot
why
come
are you still looking?
because we are giving her a second chance to attempt to meet her
Okay,
burden to show
then
it.
does she get an answer on second chance? Is second chance treated like a new application then? You get new information?
There's nothing mandatory that says that this administrative processing or re-adjudication needs to
You have
happen,
to
but
refuse, or at the end of the day, do you end up refusing or denying this second look?
it is the State Department's practice, yes, to re-adjudicate once the administrative processing
Okay,
is
well,
complete.
then it sounds like it's either you are treating this decision as sort of a renewed application, getting new information, at which point you have to refuse or deny, and their arguments about timing all remain exactly the same. Or you didn't, this is some sort of fake process here, and you really meant it the first time when you said deny. Either you meant deny or you didn't mean it. And it's very confusing to me what this administrative processing is. If you didn't mean it, that seems very relevant to this case. If you did mean it, that seems very relevant to your side of the case.
Yes, the refusal, in your terms, the State Department did mean it. It is a refusal. She doesn't have a visa. She can't come to this country. However,
That's how she was before she even applied. She couldn't come to the country. She didn't have a visa. That doesn't, to say that she can't come to this country because she doesn't have a visa doesn't mean anything. If in fact you are still in the process of deciding whether she will get a visa.
the State Department is looking at whether there is additional information that may assist her.
Right, so you didn't have full information when you made that first decision.
No, Your Honor, I don't think that's the proper way to look at it. It is the applicant's burden to prove her eligibility. She did not do that. Her visa was refused. However, voluntarily, the State Department has said, we're going to give you another chance to meet your burden. It's not something they're required to do. There's no statute that says there's a specific timeline that it has to happen in. And every case that's in administrative processing is very different, fact-specific, and requires different resources to complete.
Well, this is a 12B6 motion that you brought,
Yes, Your
your
Honor.
client brought, which means we can only look at the face of the complaint. And it sounds like what this administrative processing is, what it entails, what it means internally within the State Department is quite unknown, hugely relevant to the answer in this case, but is simply something we don't have any law or facts on the face of this complaint. So why isn't, if you want the chance to create a record as to what administrative processing is legally and factually, why isn't the right answer here that 12B6 was, we can't uphold a 12B6 grant based on something that's not on the face of the complaint and is not something that I even see in regulation or statute as existing. So we can't take judicial notice of anything. Why isn't the right answer then to remand and say, develop your record on this and then let the district court figure out what's going on? Because it just seems to be two different stories here.
Well, I think there's a few things there, Your Honor. If we're looking at the complaint, it is devoid of any facts that discussing administrative processing. There's no claim that the State Department is not adjudicating applicants that are in administrative processing. So there's no claim there. What the complaint is.
Definitely a claim there that she filed in 2019 and she has as yet to have a final answer. And I know you say we told you no, but we're still looking and we're keeping it open and we're going to make another decision after we're done administrative processing. So I am hypothesizing, at least for this question, that that's not a final answer that she's received. Those allegations are there. I filed, I don't have a final answer.
And we understand that, Your Honor. We disagree. We think this is a final answer. And we would
But
also,
you said in your own words, it's not, because another answer is coming, correct?
it is the State Department's practice to re-adjudicate once they're in.
And you said, and that's what you've said to her, she's in administrative processing, and I thought you told me, and if I misunderstood, please correct me, that there will be a final answer when you're done with this administrative processing.
That is the State Department's
Okay,
practice.
so there will be a second answer.
We can't say that for sure in her case. We don't know why she's in administrative processing. Not every case that goes through administrative processing gets a second re-adjudication. But it is the State Department's practice, whenever possible, that they do re-adjudicate based on that fact-specific requirements.
Re-adjudication could still be, never mind, we didn't find anything helpful to you, or we only found things hurtful, but she would be notified at the end of the administrative processing. I assume that's your practice.
Yes, Your Honor.
And that happens whether it's up, down, or no change.
I think it's also important to note that this
That's
idea.
of course nowhere in the record.
I'm sorry?
That's nowhere in the record, this whole administrative processing. I don't know how they're supposed to know about it.
She was told at her interview that her visa was refused, but she was being placed in
I
administrative
understand, but
processing.
she doesn't, no one understands what that means. I'm still not sure I understand what it means. There's no record here, and if you can tell me what I can take judicial notice of to understand what this processing entails, let me know.
Yes, Your Honor. On the State Department's website, they do detail what administrative processing is,
Mhm.
what it involves, and what their process is. I'm happy to provide that specific link to the court if that's necessary, but it is on the State Department's
But
website.
does it explain on there how that implicates the status of the initial decision?
It doesn't, because the initial decision is a decision. That is the refusal. Her visa has been refused. The State Department could have said, you're refused, thank you, goodbye, but
Say that we will give you an answer when we're done with administrative processing?
it says they may. They may give another answer because there may be some new information that shows they are eligible, but there could be information that reaffirms the refusal.
Is administrative processing distinct from when you ask the applicant to provide additional information, or is that part of administrative processing?
That is a type of administrative processing, Your Honor.
Okay, so does Is she supposed to know somehow? Is there something we can take judicial notice of that lets her know whether you're getting want information from her, or you want information from other entities, or both?
If there was additional information required, she would have been informed at the interview, but the reasons behind the denial are clearly barred under consular non-reviewability. She wouldn't be entitled to know the specific reasons.
No, I'm sorry, what you're doing the administrative processing for, not for the decision, but what it is that she's being administratively processed for, getting information from somewhere else, or from her, or from both.
That's not information we have in the record, nor should it be under consular non-reviewability. The State Department needs to be able to.
That's not a decision. That's just what kind of administrative processing is she in? That's not a decision by the consul on her visa application. It's just a categorization. It's no more unreviewable in the fact that you're talking to us about administrative processing.
We
We're
would
asking to make a ruling based on that.
I understand, Your Honor. The Second Circuit has expanded consular non-reviewability to involve the entire process of a visa review, and that would include the reason for the administrative processing, because it would necessarily indicate what was missing from the application or what steps the State Department was currently taking, which the doctrine protects to allow the State Department to do the work that they need to do and safely and
Well,
securely.
in this case, we have the email exchange where Karamova said, you asked for more, I gave you everything you asked for. And we don't know whether there's anything else. The government hasn't said, oh, we need more from you, or that's fine. Everything we need from you has been provided.
Correct, Your Honor. That's all that's in the record is that email.
And she's not entitled to anything more than that. And
That's correct. As a non-resident, non-citizen, she's not entitled to any more information.
now, if we were to accept the government's view here, it seems like that would invite any government that is chronically delayed in its action to adopt this kind of a process, to say denied, but of course, we'll still look at this, and if it occurs to us that maybe there is something here, we'll let you know. And why isn't that deeply problematic?
I think it's, the way to think about it, Your Honor, is not that they're holding it in abeyance if something occurs to them. She did not meet her burden. They told her that. And they could just send her on her way with that refusal. But the State Department wants to encourage people to come here. We want to assist people to meet their burdens. So we're giving her this second bite at the apple, so to speak. And the State Department is assisting her. Perhaps there's information with other agencies. Perhaps there's other information out there that the State Department can gather on her behalf that might assist her in meeting her burden on the readjudication. But none of that is required. There's nothing that says the State Department must give these applicants a second chance to prove their burden.
Can I just do one other quick question? You would refer here to a status called withholding, which is not one of your grant or deny options. And I know that phrase withholding shows up in our Bantai case and our Savadra case. What does withholding mean?
Withholding is a refusal. The visa has been kept.
If you grant, refuse, withholding, it's treated as a third category.
Not under the regulations.
So
Your Honor.
withholding means when it's, whatever the phrase is there, that means actually denied,
It means refused.
refused.
Yes.
You don't do deny, you just do refuse.
We do, under the State Department regulations, yes. They use issue or refuse.
Issue, refuse, or discontinue granting.
Yes, or revoke I think is the associated phrase with that.
So discontinue granting doesn't mean discontinue the process toward a potential grant. It means revoke.
That's my understanding, Your Honor, yes.
Okay. On the district court said that the government uses a first in, first out rule of reason. I don't see that anywhere in the record. And I take it you don't either.
On the track factors for the first in, first
Yeah,
out rule.
assuming that there's jurisdiction and we're looking at whether the government applies any rule of reason to processing visa applications under the INA.
Yes, so the government, first of all, is entitled to the presumption of regularity. And the interview scheduling is done on a first in, first out basis. Here,
Know that, is there anything in the record to show that?
I think the timing of her application would show that. She applied in October. She had an interview by January. So it was only 3 months between application and interview and refusal.
That, I mean, it's not inconsistent with an inference that it's first in, first out, but there's nothing. There's no affidavit saying we do the interviews on first in, first out. We really don't have anything. I mean, it was on a motion to dismiss, to be sure, but
Yes, Your Honor, but it is Ms. Karamova's burden to show that these track factors fall in her favor and that there is no rule of reason being applied. And here, the allegations in the complaint are very conclusory, similar to the DaCosta case, where this court found that conclusory statements that they're not applying a rule of reason is not sufficient to support that track factor.
there were declarations. I mean, there's, the government often will come in because there are jurisdictional implications. And so even though it's 12, Rule 12 motion to dismiss, it could be Rule 12B1. It's just striking that in this case, there's nothing from the government saying, hey, this is how we do it. We have a rule, we have a process, we're following the process. Nothing like that.
Yes, Your Honor, there is nothing like that in the record, but I think looking at that timeline indicates that. And I also think the complaint claiming that the 3 to 4 year delay shows no first in, first out ignores the undisputed fact that she had a decision on her visa 3 months after the application. And now we're in administrative processing, which is different than that initial adjudication where that first in, first out would be applied.
Your website says this administrative processing will be done in accordance with department procedures. Where are those procedures? Where can I see those?
I'm not sure, Your Honor. I'm happy to file a supplemental if Your Honor would like.
There's written procedures somewhere.
I believe they would be probably in the State Department regulations or internal procedures.
And then it says,
It would be helpful if you would submit that.
yes, and it also says when administrative processing is required. When is it required?
It depends on each case. The consulate officer.
Sorry, where's the standard for deciding whether it's required or not?
So on their website, it says an officer may determine that additional information from sources other than the applicant may help establish, and that is when it would warrant a further
I know,
administrative
but if you keep
processing.
reading down, it says when administrative processing is required, the consular officer will inform the applicant at the end of the interview. So what I would like to know is when is it required and where is something that I can take judicial notice of to understand that meaning of when it's required?
I think that
You kept
means,
saying it's voluntary discretionary, but the website you refer me to says when it's required.
I think that means when the officer decides that it is, like, it's warranted.
That's what you're telling me, but I can't take judicial notice of that with all respect to your effort to be helpful here. If your website says it may sometimes be required, don't we need to know what that means?
Yes, sir. I only have the information that's on the website. That's how I read that. That it is when they have decided that it's warranted, and perhaps it's just a different word choice when they say it's required.
Oh, there's a very different thing between warranted or in our discretion and required. And since you mentioned procedures before, it would be helpful if there's anything State Department has that says when it's required, that would be very helpful to know.
Yes, Your Honor.
Can I ask you, in your view, does a consular official have any non-discretionary obligation to adjudicate an immigrant visa application
In the first instance,
at all?
respectfully, that's not a question that's before this court, because her visa application was reviewed and rejected.
Well, it is before this court because as opposing counsel pointed out, a lot of the districts and the Ninth Circuit have said that the refusal is not actually action. And if we were to agree with that, then we would have to figure out whether that action or whether there is a requirement, excuse me, of a non-discretionary obligation to adjudicate an immigrant visa application.
I think whether or not there is a duty to adjudicate in the first instance, I don't know that that's in dispute that they fulfilled that duty here. If we assume it is without deciding.
Well, you just gave me the same answer that I said I wasn't, assuming for purposes of the question that I disagree with you. If there is an application pending, is there any duty on a consular officer, non-discretionary duty to adjudicate it? If there were one pending?
In the first instance for a first adjudication?
At all? First adjudication or after denial, but.
After denial, there is definitely no.
Okay, so in the first instance.
In the first instance, You are correct that different courts have come down different ways on this. There is case law saying that there is no duty to adjudicate in the first place. But again, that's not something the parties have really grappled with here because she did get an initial adjudication.
Well, the plaintiff says there's a duty under the Administrative Procedure Act, 555B. And what's your position on that?
555B is very open-ended language, and there's no reference to visas. There's no specific unequivocal command ordering a precise, definite act that the Norton case requires from the Supreme Court. So, I mean, when we're talking about.
There's no reference either to tribal recognition, and we held in Mashpee that 555B was created a non-discretionary obligation to adjudicate a tribal recognition petition.
Yes, Your Honor. As you pointed out to my opposing counsel, Norton came after Mashpee. I also think the facts of Mashpee distinguish it from here. I think the Department of Interior reviewing those types of applications is very different than the State Department reviewing a visa application, where there are a number of statutes and case law that says how a visa is adjudicated and what the State Department does is in the discretion of the State Department and the legislative and executive branch. And the judiciary is not going to climb in and second guess what happens there.
No, but not whether it does so. I mean, you yourself said they either deny or grant. I mean, is that such a hard question to answer? Is it your position that the statutory requirement under 1202B, providing that all immigrant visa applications shall be reviewed and adjudicated, that they don't actually have to adjudicate?
I'm not going so far as to say that, but courts have said that 1202B is not a source of a clear non-discretionary duty. But again,
The government seems to have read it differently in the regulation that I thought you were citing, which is requiring a consular officer to issue the visa or refuse the visa or discontinue granting the visa. Like, it's requiring action, no?
yes, Your Honor. But I don't think that goes so far as to say that there is a non-discretionary clear duty. And the question of whether 1202B requires the adjudication in the first place is actually an open question pending before this court in the Good Luck case.
Thank you. Just one quick question. You referenced that you do this administrative processing for diplomatic reasons.
Yes, Your Honor.
Where could I take judicial notice that administrative processing is done for diplomatic reasons?
Perhaps diplomatic is not the right term. It is the State Department's policy. Like, we don't want to.
Where is this policy that I could take judicial notice of?
I don't know that it's an official policy, Your Honor. It is the State Department's practice that we want people to come to this country. We want to give them that
Is
chance.
there anything we can take judicial notice of, or is this just something factually that needs to be developed?
I'm not sure, Your Honor. I'm happy to check and get back to the court on that.
All right. Thank you, counsel.
Thank you very much for your time.
Does Mr. Piston have any time? All right,
I
2
know I
minutes.
overran my prior time. Do I still get 2
Why don't
minutes?
you take 2 minutes?
Okay. First of all, Your Honor, the government made reference to a presumption of regularity as an explanation of why she thought that the consul must be doing things on a first in, first out. But the presumption of regularity presumes that government officials will comply with the law. There's no law requiring the consul to process cases on a first in, first out basis. Rather, that comes from the rule of reason in the track case. So the presumption of regularity doesn't really apply here. Second of all, I'd like to point out the fact that even though she did say that the consul process case on a first in, first out, there's absolutely nothing in the plaintiff's complaint, certainly, that says that, and therefore this is not something that this court can consider unless, of course, they take it under judicial notice, and there's nothing to judicially notice here, except this allegation exists nowhere except in the argument of opposing counsel. Also, I'd like to.
What do we do with the fact that your complaint alleges that she filed in 2019 and no action was taken on her application, when in fact she'd had an interview and a decision called refused but that didn't appear in the complaint. What are we supposed to do about that?
Your Honor, I don't have the exact language of the complaint in front of me. If I use those
I promise you,
words,
it doesn't say that she had an interview and that she has a decision that says it's denied, but we're doing some administrative processing. That's not in there.
what I'm sure we did say was that her visa was neither issued or finally refused. And that's our position in this matter. And whether she was interviewed or not really is neither here nor there.
The complaint was all about no action. It's a very different question when there has been action and then there's another layer of action from no action.
Your Honor, if I might be allowed to file a supplementary brief on that matter, I'm quite certain that we did take the position that the visa had not been refused or issued.
We'll let you know about that.
Okay, thank you. Thank you very much.
This honorable court will now take a brief recess. Stand, please. This honorable court is again in session. Be seated, please. Case number 23-5159, Matthew D. Green et al. Appellants versus United States Department of Justice et al. Mr. Margot for the appellants, Mr. Springer for the appellees.
Mr. Margot, good morning.
Good morning, Your Honor. May it please the court. 17 USC Section 1201A grants the power to a component of Congress to decide who may access works of authorship. That is the power to decide who can access speech that might be in their lawful possession, and by extension, to decide who gets to make high-quality copies for fair use in their own speech. This speech licensing regime thus regulates not the location of news racks or the timing of an event in a Chicago park, but the content of speech. It fails minimum procedural requirements applicable to speech licensing regimes for 3 reasons. First, it lacks clear standards. The Romanet 5 catch-all exception is enough alone to fail the constitutional test by allowing the librarian to consider other factors as considered appropriate without limit. Second, there's no requirement of prompt decision-making. That can be a flexible requirement, as was seen in this circuit's case in Boardley in 2010, but nonetheless, the lack of any promptness requirement fails the test. And finally, there's no provision for judicial review of the librarian's final decision. If the scheme were organized so that the Copyright Office and not the librarian were the final decision maker, there would be Administrative Procedure Act review. As it happens, the librarian is protected by sovereign immunity.
Mr. Mango, if the statute, instead of having the criteria that it has for the Library of Congress to issue periodic exemptions, it just said the Library of Congress will issue periodic exemptions to make advance determinations on categories of speech that are clearly fair use, would you have the same objection that you're raising here?
Yes, Your Honor. That sounds like fewer standards or less clear standards rather than more clear standards. It might be worse constitutionally. And just a point about the fair use right considered so important in Eldred and Golan. It's an individualized right to mount an affirmative defense. It's notoriously fact-specific. It's adjudicated by judges, and the common law is developed that way. And dispensing fair use in gross in advance to broad categories of speakers is content discrimination, not a salutary.
It doesn't, that's a puzzling answer to me because it doesn't dispense, presumably, with a fair use. If the fair use defense is a First Amendment right, then why isn't that available, whatever the statute says?
Your Honor, if this court were to follow the Federal Circuit in the Chamberlain garage door opener case, that is not how the government interprets the statute. That's not how the librarian interprets the statute. But if there were an affirmative defense to say, my 1201A circumvention is not linked to infringement, either because I only want to read the work or because I want to make fair use of the work, that would satisfy the Constitution with respect to the overbreadth claim. That would leave untouched the problem of speech licensing and the standardless decision-making process.
Why would it, if the standard were the fair use standard, why is that standardless decision-making to say, on the one hand, anybody who brings their claim to the court would get a court adjudication regarding fair use. But in order to give people, extra comfort, the Librarian of Congress is going to do categorical ex ante fair use exemptions. And everybody else who might be more particular or might not have been addressed or might not have the money to bring a petition to the Library of Congress would still have their fair use defense. I'm not sure why it's a problem to have the ex ante effort to alleviate that burden.
If the librarian had a broader standard to apply.
If the standard were the fair use doctrine.
Were the fair use doctrine. That might be a clear enough standard if the Romanet 5 catch-all consideration that allows exogenous policy considerations to creep in, if it was only the fair use standard, that might be sufficient. There would also be a requirement of prompt decision-making and the requirement of prompt judicial review to make sure those standards were reasonably applied.
You
I wanna-
talk about it being speech licensing. But what it's licensing is circumvention. The circumvention is to the end of engaging in speech, but what's being licensed is circumvention. Is your position that all circumvention barred by this statute is speech?
Your Honor, circumvention is defined here as, it can be defined as bypassing or accessing a work that's protected by a technical measure. Nothing more is required than to somehow bypass.
It is the bypassing or decrypting. It is the act of getting to something that is a circumvention. It's not the something that you get to. It's the act of getting there. It's not the destination that's regulated here. You could think of this as, barring driving around on roads that are blocked off for construction instead of staying on the main way, right? You can't do that regardless of your destination. This is about the process of getting to something that's speech. But what I'm asking you is circumvention, the process of getting to something that they may want to read or look at. Is the process itself categorically speech?
The process of circumventing is only applicable to accessing a copyrighted work. It's simply so close to.
I understand that, but you just said the circumvention is to access something. Now that work,
Yes,
no
Your
doubt,
Honor.
is the speech of the copyright holder, no doubt. And so what I'm struggling to understand here, whether you're saying the mechanical or technical acts of engaging in circumvention to get to the goal is the circumvention itself speech?
So, Your Honor, if I have the DCSS
Can you just tell me
decryption
yes or
key.
no? I think, and then I promise I will let you explain after, but I'm just, my brain.
We're
is
not
having trouble.
arguing that the decryption key is speech. We're not arguing that the act of unlocking it is expressive, but it
Is the act
is
of
part of the
bypassing
speech
expressive?
process.
Is
Sorry?
the act of bypassing protective measures, technological protective measures, speech?
The act of reading is speech.
I didn't
and
ask you that. I
the
asked
act
of
opening
bypassing,
the
of
book.
getting to it. You can read it when you get there. Is the act of getting to it speech?
It's either part of the speech process or it's
I don't,
conduct so
okay, so
closely.
explain to me what you mean by, so your argument is that all acts of circumvention are themselves speech.
My argument is that circumvention is so closely related to reading that it's
But that's
closer
different,
than
because
news
what's
racks.
licensed here is circumvention. And you said this was a speech licensing regime. But what you, sounds like you mean is what they're licensing here is technological means of being able to engage in speech. That's your objection. That's different than a speech licensing regime.
Well, Your Honor, I think it's so closely related that it's more closely related than reserving a soccer field in a park. It's more closely related than figuring out where your news racks are going to be. It's
Why, tell me why it's more closely related.
because if something is protected by a technological protection measure, there is no way to read the work without, by definition, circumventing, even if you merely bypass or avoid the
That doesn't
technological
make it
measure.
more related or not. There's no way of putting newspapers out on newspaper racks without actually putting racks out there first, right? But the placement of the rack, if I just wanted to engage in putting old, unused newspaper racks, littering them across the city, no intention of putting newspapers on them, that would not be speech, assuming I'm not doing this some sort of performative art. So that would not be speech. I just want to, I got 1,000 of these in my garage. I want to get rid of them. I'm just going to put them all around the city. That, of course, would not be speech. That, of course, would not be speech. Can we agree on that?
It is not speech to place objects on the ground for no speech purpose.
Even if
Yes.
they are actually designed to hold newspapers.
Well, if
That's what they're designed.
if somebody
for.
else designed them and I'm merely dumping them in
I'm
a
just
garbage
merely
dump, that's
dumping
not
them there.
speech.
Really, right. So
of
it is,
course.
the reason the protections were for newspaper racks was because they were going to be displaying speech.
Precisely.
But
and
the licensing, a rule against putting things out there is not itself a speech licensing regime. You have to show that the function, and in that case, the sole function, design and purpose for putting them there was to put newspapers onto them.
Well, Your Honor, I think the
Yes.
analogy would be a law forbidding placing news racks. And of course, they're going to be, I mean, you could imagine a case where somebody's dumping a news rack, although here I don't think you can. I don't think it's possible to read a work protected by a technological protection measure without authorization unless you bypass or avoid
No,
the
but
measure.
there's all kinds of people who want to bypass and avoid things so they can steal them and make money. They may never even read them. They just want to sell them. That's not speech, is it? Stealing it to sell to make money, is that speech?
The act of reading the work is speech. The
Sorry,
act
I
of-
didn't ask,
it's-
so I'm imagining someone here engaged in piracy measures. And so they want to decrypt or circumvent, whichever verb you want to pick out of the list. They want to do it so they can get access to this material. It's a very highly anticipated book that hasn't been released yet. And they want to sell it because they can make a lot of money. They have no intention of actually even reading it. They just want access to this document so they can preempt the copyright holder, sell it, and make a lot of money in a bootleg market. Is there anything involved in that that is speech?
Yes, Your Honor, piracy is speech, but forbidding it doesn't violate the First Amendment, as we learned from
What
Eldred and
case
Golan.
holds it? Piracy, the stealing is speech. So if I steal books out of a bookstore, I'm engaged in speech?
If you physically steal a book with the intention of reading it,
No,
That's-
I didn't say that. I said I physically steal books out of a bookstore. Is that speech?
if you're physically just moving paper with no, and you're not reading it at all, and you're
Well, my
not
hypothetical
distributing
was
it to
I'm
anyone.
physically stealing this copy of a book, electronic book of some sort. I'm physically stealing it. Said I didn't want to read it. I just want to
Right.
sell it. I'm going to make a hot dollar off of selling this on the internet. You said all piracy is speech, and I'm questioning that. I don't understand why piracy is different than theft.
Piracy in the sense of distributing speech is speech. It's just permissible to prohibit it under the First Amendment.
And
The
so
First
if I
Amendment-
go in and steal books out of a bookstore,
Right, then we
and
now,
then I keep them in my house, is that speech? I'm not looking
well,
at them.
if a book is stolen and no one's ever going to read it, perhaps that is not speech. But
Okay, but
if
if
I
I
steal,
steal it and then sell it,
if I
that is
steal it to
speech.
sell it, stealing is conduct
what is your
necessary.
best case that stealing books and selling them is itself speech?
Well, I go to the logic of Golan and Eldred, where copyright grew up at the same time and has the same tradition as the First Amendment.
I don't think
Copyright
those
within
cases
its-
involve stealing and selling.
I don't have a case where anyone cared whether distributing pirated goods was speech, because it is permissible under the First Amendment to prohibit it.
So
okay.
your argument, I think we sort of got into a further line of questioning when Judge Millett was asking you, what is the speech that's at issue? And am I right that it is speech, fair use that depends on circumvention? That's the speech you're talking about?
The speech is both the act of reading the media and the act of taking fair use copies of parts of it to create your own speech. So it's not that the decryption key, DCSS, is speech. It's that my DVD in my house contains speech. I want to read it, and I want to take fair use clips of it for use in my own
So it's
speech.
reading and or fair use that depends on circumvention?
Yes.
Sorry, when you say, I should make sure I understand that answer. When your decryption technology reads their encryption technology to unlock your access to the ebook, is that decryption technology reading the encryption technology itself speech?
No, it's conduct that's
See?
necessary for the speech
To
process.
get
It's part of the
to
speech
the
process.
end product. For fair,
Well-
then you want to use that end product for fair use purposes.
The necessary and immediately following obvious results of the step. Yes, the next step is speech.
You put a whole lot of necessary and obvious that are neither necessary nor obvious to decryption in my view, but
Well, Your Honor, decryption is not necessary for circumvention,
Okay, I'm
nor is
just making clear
descrambling.
that again, the acts of circumvention, whatever way you're doing it, whether you're decrypting or unscrambling or bypassing, going around, any of those that are listed in the statute, you're not arguing that that's not the reading that you're talking about, or the information gathering that you're talking about. It is only the copyrighted product at the end and the uses of that you are claiming as speech.
Correct. I'm not saying that the act of
You're saying-
opening the book is itself expressive. It's just necessary to read the book and necessary for me to make fair use of parts of the book.
Okay.
And so can you give us examples of the kinds of fair use as to which circumvention is essential?
Yes, Your Honor, the filmmaker amici talk about this, and we're on a motion to dismiss, of course. We have this in the complaint, discussed in the complaint. So filmmakers take fair use clips of other films and take images that are used, documentarians, but also narrative filmmakers. Security researchers like Professor Green take the speech that's in objects or systems and then create scholarship citing that. And then yes.
Can you explain that again? The second one?
Well, yes. So if Professor Green.
Security researchers.
Yes. If Professor Green or other security researchers have a piece of media or an object that's filled with code and code being speech there, they read that, understand it, and then create research to inform the public or to inform those who could correct the security problem. There are also blind and print disabled people who merely want to read the speech. They may not be making fair use, but they're reading the speech.
But is it a violation of the First Amendment to offer a product with limitations, like to offer a print book that isn't automatically read aloud to you, or a film that you're paying a low price for because you only get to watch it for a limited period of time, you don't get to copy and manipulate it? It just seems like when you talk about ownership, you're reading a lot of things into ownership that were never offered or purchased.
Yes, Your Honor, I agree that some of the examples that the government mentions without citation to any record, because we're just on the motion to dismiss record without discovery, on page 21 of the appellee's brief, these sound like the sorts of things that would be ordinary consumer uses of media. We don't know the details of those, haven't been explored below. But we're not contending that creating a contract around reading a piece of speech violates the First Amendment. Contracting parties.
So you're reading disabled, or I can't remember the phrase you used, but if somebody can't read their ebook without decrypting it so that they can make it more accessible, why isn't that subsumed by the acknowledgement you just made? It's not offered to them in that way.
That case might be adjudicated that way. I don't know.
But that's one of your examples. So your examples are filmmakers. If filmmakers are doing fair use, then they're not liable.
Well, Your Honor, we're just saying, so for purposes of the speech licensing claim, we're claiming that it's speech and that the librarian gets to pick winners and losers, gets to decide.
But is your position that the librarian's picking of winners or losers displaces a fair use defense that would otherwise be available?
No, Your Honor.
And so how does it disadvantage a filmmaker who is able to decrypt, wants to fair use clips of someone else's film?
I would point the court to Boardley from 2010. There, the person who was required to get a speech license wasn't denied a license. He was allowed to leaflet in the park, but nonetheless, the court overturned the regime that would have allowed arbitrary decision-making.
Except there's a ban on leafletting if you don't have a license, whereas here, there's no ban on fair use if you don't have a categorical exemption. The categorical exemption is saying you don't even have to get into a situation in which someone goes after you and sues you for copyright infringement, because we're going to tell you up front that this swath is fair use. But you still, as the filmmaker, Disney can still do fair use and make some parody of someone else's film. And if they get sued, they said fair use.
Your Honor, there is a categorical prohibition here. It's in 1201A. You're categorically prohibited from accessing a copyrighted work without the authorization of the copyright owner if there's a technological protection measure on it. Some people get out of that prohibition because they gain the favor of the librarian. Some do not. And that is separate from copyright infringement. Those who try to make fair use when they're not able to circumvent, they have to tend to use lower quality media. So
Right.
if you have,
And is quality of media First Amendment protected?
yes, absolutely. Two Live Crew in the Campbell case was entitled under the First Amendment to use a high quality sound recording of Roy Orbison's great guitar lick from A Pretty Woman. If they weren't, if they had to.
That case wasn't about what level. I mean, that was about whether parody was protected at all. It didn't say that you have a First Amendment right to the highest tech version of any medium, any, there was song or book or anything out there. There's no First Amendment right to that.
Well, Your Honor, that case did say that you need to be able to take as much of the work as you need to make parody of it.
That's very different from what quality form you're going to get it in. I don't understand why you say that we need to be, that there's a First Amendment right to get everything in the highest quality form in which it is available.
I only say that there's a First Amendment right not to be prohibited by the government from using the high quality version in your lawful possession.
If the well, that again, that just begs the question of what's in your lawful possession when you purchase an ebook. If you purchase it subject to conditions and requirements, then you only own what you purchased.
Well, we're on a motion to dismiss and there's no ebook conditions or terms of service in the record here. That might be one of the examples.
I think we can just take as given that nobody is selling the right to, if you could identify in your complaint an allegation where some copyright owner, when they gave you access to an ebook, or you had access to watch a movie on your Netflix, meant you had access to do it any way you wanted, regardless of the conditions put on your acquisition of it, let me know. But
Well,
I
Ron-
don't see that in your complaint. And if you don't, if it's not what you're buying, it's not what you're buying. It's like, you're like leasing a car here and you want to say, fine, now I can do anything I want with that car. And there's nothing you can do about it. And that's not how it is. It's still their property. You're just leasing it.
Your Honor, I
You
own
can't put nails in the
DVDs.
wall of an apartment.
I don't have any contract relationship between the copyright owner of the people who made the songs on my DVDs or the movies. I own the DVDs. They contain
You own-
speech. And I submit that
All the
reading the
DVDs subject to the protections that are on them. And subject to piracy laws.
yes, Your Honor, which has a fair use provision in it, which is why
Do
piracy
you
is,
think all fair use is protected by the First Amendment?
I think so, because that's how
Do
fair
we have
use is
to
defined.
decide that to rule in your favor, that all fair use is constitutionally protected?
No, Your Honor, because the way the government interprets this statute, there is no fair use defense at all. So you don't need to determine its
But I mean,
extent.
you're talking about speech licensing and integrally related to speech, but if in fact, a lot of the fair uses you allege in your complaint are not themselves constitutionally protected speech, unless we hold that every fair use, that one, they qualify as fair use, and two, that all fair use is constitutionally protected, we can't get to your theory of the case, can we? And that's a big question. The Supreme Court has said time and again in the VHS case, well, yeah, we think you can do this, but Congress can certainly revisit it. Right? They don't normally say that when something's protected by the First Amendment.
Well, Your Honor, I think we plausibly allege examples of filmmakers and others who are making fair use. And it would also be possible for this court to merely say that the district court at JA 286 and 87 was wrong in sidestepping the entire overbreadth question by invoking Citizens for Vincent. Respectively, this isn't a Citizens for Vincent case. The as-applied claims that are no longer in the case are different from the overbreadth claim that remains.
But can we even find that there's an overbreadth claim without understand that overbreadth claims aren't allowed under the COP for fair use? There's not a fair use overbreadth claim. There might be a First Amendment overbreadth claim. So to have an overbreadth claim, you're going to have to show that all the speech is not just fair use, but in fact is protected by the First Amendment. Right?
Yes, on a record, once we have discovery, we would have to show
No, but first
burdened.
you have to allege it in your complaint.
Yes, Your Honor, and in the
So how
record,
do I know that the examples that you have given and post-green. So we know that Mr. Wong's technology doesn't count as protected for these purposes. So where have you alleged that, or how do I know from the examples you've given of people who want to take longer clips than the licenses allow, who want to take, to convert things from one format to another, from ebook to audiobook? How do I know that that is First Amendment protected speech?
Well, Your Honor, in the record, the Copyright Office's 2017 report does acknowledge that there were fair uses and free speech rights burdened. The Copyright
There were
Office.
some, but you overbreadth doesn't get to say that there were some that were burdened. It's
Yes,
not
Your
even
Honor,
enough
but-
to say that 49% were burdened. Probably not even 51%. It has to be a lopsided ratio. So where do I get that from your complaint?
Well, Your Honor, I would just say that overbreadth claims like Stevens was on a full criminal trial. These overbreadth claims tend to be on a thick record with summary judgment or trial. Our complaint alleges various uses that we assert are fair, whether if you tot up the exact percentages
Can you
of people.
identify an example from your complaint that we can tell, applying our Green One precedent, is a First Amendment violation? Do you have one example of an actual First Amendment violation alleged in your complaint post-Green?
Is Your Honor suggesting that it would be so much detail that this court
I'm
could?
asking, I'm not aware of any overbreadth complaint because Mr. Green's out and Mr. Wong, we held in Green One, is not constitutionally protected. His technology is not constitutionally protected. So, and now you've got other allegations about them and about other people. But to state an overbreadth claim, it seems to me that the one thing you should be able to do is identify one person whose speech that you seek to protect, we know is constitutionally protected. A very easy thing to do in the Stevens case. I just don't see it here.
Well, Your Honor, Professor Green, I submit, has standing. The last panel said he lacked standing on the as-applied claims to get a preliminary injunction. Professor Green today is participating in the
Government has said
2024.
his speech, his book selling is not, his book is not even the type of medium that's regulated here as circumvention.
But
or trafficking.
for circumvention, he would rely on the 2024 rulemaking, giving him another exemption. He's participating in that now under the standards of standing in.
He may have gotten an exemption from the Librarian of Congress, bully for him, but where does that show me that you have precise conduct that actually violates the First Amendment? Do you agree that to state an overbreadth of claim, the complaint must at a minimum identify one person whose conduct is plainly protected by the First Amendment, that we can tell that from the face of the complaint?
I believe that you have to plausibly allege, yes, but I think that fair use is so notoriously fact-specific that it would be too high a standard to say that you have to
So in
allege.
this area, you want a special rule in this area that to state an overbreadth claim, you don't have to identify anyone whose conduct is on the face of the complaint protected by the First Amendment, just that you can allege facts that someone later down the line, after discovery, might or might not conclude plausible has a First Amendment claim. That's the pleading standard.
Not at all, Your Honor. I just want Twombly and Iqbal to apply to motions to dismiss and overbreadth claims.
But you want way more than normal Twombly-Iqbal. Overbreadth is a special category. And I'm just not aware of a case in which it was considered by this court or the Supreme Court, or you can tell me any other appeals court, where nobody could identify a named plaintiff or anyone else listed, where we know there's a First Amendment problem. Might be,
Your Honor,
maybe not be, but we don't know.
The narrative
To
filmmakers
allege
who,
overbreadth, because that requires a volume. And if we can't tell from the face of the complaint, we're not sure there's even one, maybe, maybe not. How do I know that you've alleged an overbreadth claim, as opposed to maybe some as-applied claims?
Your Honor, narrative filmmakers were denied an exemption. K-12 instructors were denied an exemption, whereas college professors were allowed the exemption.
Okay, so let's start again. So these K-12 instructors, I get they want to use that copyright material at the end. Do these K-12 instructors claim to have the technological capability themselves to circumvent?
Yes.
They have the circumvention capabilities?
It's widely available, as in Corley, it was on the internet openly. Yes.
So they are ready to use this. They have the systems and they are ready to use this technology to circumvent. I understood from your
Yes.
description of them that they simply want to use this material, and all you allege that they want to use this material in certain ways, not that they actually themselves wish to
No, if I'm a,
circumvent and get the material,
Correct.
as opposed to someone else getting the material and then they'd like to use it.
no, if I'm a fifth grade teacher and I have a DVD in my house and I need to get a clip off the DVD, I want to show a 30-second clip of the DVD to my kids in the full definition. And to do that, I would need to get DCSS off the internet or some other commonly available tool.
Okay, and then we know that that K to 12 is use, contrary to the copyright holder's intentions and desires, is First Amendment protected because of what?
We know because it's fair use, because it would be a
That's
short
back to
clip.
saying
It'd
that
be-
all fair use is necessarily First Amendment protected, which the Supreme Court has never said.
Your Honor, fair use is notoriously fact specific. So I could invent a hypothetical where one fifth grade teacher uses too long of a clip and it's not transformative use. That might not be fair use, whereas another fifth grade teacher uses a short clip and it's for a specific purpose that in context makes it clearly fair use. They might use it as a parody.
But the fact is, does that make it First Amendment speech? When it's being done, when they want to copy something against the will of the copyright holder, and yet it is still First Amendment protected, not fair use, First Amendment protected.
Yes, Your Honor, I believe that under Eldred and Golan, the fair use is considered to be an essential accommodation to the First Amendment baked into copyright law.
It didn't exist initially with copyright law at all.
Fair use, well, I believe it existed since Justice Story and Folsom versus Marsh.
Did the first copyright statute have a fair use provision?
The Copyright Act codified a pre-existing common law right that I believe goes back to England. Your Honor.
Are you sure the common law right had a fair use provision?
Yes, Your Honor.
What's your best case for that?
Folsom versus Marsh, Justice Story.
Okay.
I have a remedial question, which is if we were to agree with you that the Librarian of Congress triennial review is an unconstitutional licensing scheme and invalidated that, then the rest of the statute could stand.
I believe it would only affect a 1201A circumvention regime because the trafficking portion, there's nothing in trafficking would be affected at all.
And it would be, but it also would be severable from the anti-circumvention provision.
Yes, Your Honor.
So, and then would the remaining law be unconstitutional? The law that prohibited circumvention and trafficking?
That would be unconstitutional only if we prevail on our overbreadth claim.
And why isn't your overbreadth claim determined by the first appeal in this case?
Because it wasn't considered there, the first panel said it did not have jurisdiction over that claim. So while I take it that on the preliminary injunction record, we have a holding that the net VCR, is not, can be constitutionally prohibited. That's essentially all we have there.
The court said that the DMCA's incidental restriction on alleged First Amendment freedoms is no greater than is essential to the furtherance of the government's interest.
Yes, Your Honor,
That
that's,
doesn't suffice to foreclose us from finding overbreadth.
not at all, Your Honor. The last panel from I believe, one of the first sentences of the opinion and
Yeah,
throughout
no, I know
makes
formally
clear
they
that,
said we're not ruling on the overbreadth claim, we're only doing as applied, but I'm just looking at the rationale in that case.
yes, they were focused on the decryption key. The way they phrase it, it's that people who write code have a First Amendment right to write decryption code. So here, we're not talking about the decryption code. We're talking about the content of the DVD on my shelf. And we're talking about the fair use clips I'd like to show to my fifth grade class.
So again, you're looking at the use, fair or otherwise, expressive uses of materials that are now behind an encryption wall.
Yes, but both the reading and the use. So I read before I then incorporate it into my own expression, and both are protected.
Why do you think if we invalidated the librarian as gatekeeper, that you wouldn't be deprived of the escape hatch and you wouldn't be able to get past the protective measure?
Your Honor, I believe typically when a statute is struck down for violating the First Amendment, the remedy tries to level up to allow more people to speak rather than leveling down. But also, even if the librarian as gatekeeper were struck down and then the exception process were eliminated, it would eliminate this distinct First Amendment evil, which is having an unaccountable and standardless decision maker pick winners and losers.
But wouldn't you then be without any way to get around the anti-circumvention provision?
Yes, if the entire, if that was the remedy, yes, our particular plaintiffs would be without the triennial exceptions until such time as Congress corrected the statute or amended the statute.
And how would Congress do, I'm sorry.
So it wouldn't be severable.
Well, Your Honor, I'm just going with your hypothetical. I apologize, I'm not sure if I understand. I believe that the whole circumvention portion of 1201A.
Let me try to make it clear. Right now, you have an avenue to get around the anti-circumvention provision. You're challenging that. And if we agree with you that that exemption with the librarian as gatekeeper, without the judicial review, without the prompt review and so forth, is struck down, you're left with no way to get past the protective measure.
Your Honor, in Boardley, Mr. Boardley got a license, but then he attacked the licensing regime, which this court struck down. I believe that the remedy there was that anyone could leaflet without a permit. They enabled more speech rather than restricting speech.
But we wouldn't necessarily have to so hold. I mean, you answered my question about severability. Take away the triennial licensing scheme and just leave in place the ban on circumvention and trafficking. Arguably, that gives the readers and speakers that you're concerned with less guidance, less security against enforcement, but it does take away the Library of Congress's role, which I gather to be the core of your anti-prior restraint argument. So you sort of have like restraining less speech, but introducing this ex ante control that you mistrust, or functionally restraining more speech, but with only the courts being the adjudicators. And you're favoring what I put second, what I just described second.
Well, yes, for purposes of the speech licensing claim, I do believe that it needs to be, the triennial rulemaking would need to be invalidated. I look at, the Town of Gilbert case. There were sign regulations that admirably allowed political and ideological signs to be very big, bigger than other signs. Nonetheless, that's content discrimination, and the ordinance was struck down.
What other than the fifth other factors provision is really problematic, unguided? Reading it seems very much trying to codify something akin to fair use, maybe even broader.
Your Honor, I believe that the statute could be corrected only by eliminating the Romanet V catch-all.
It could be.
Yes, or by saying that essentially if all it means is that the librarian may consider whether classes of works are the prohibition is going to have a negative impact on speakers in the next 3 years, and Romanet 5 just means if something's directly relevant to that, then consider it. If it were narrowly construed like that to exclude, bringing in auto emissions policy and the like, then that would be permissible.
So that would be a full relief from your perspective if it was just read in a kind of a jus dem generis way, that this V is to be read in the context of Romanet 1 through 4 and in the service of those, then reading it that way would cure the problem that you have. That
would cure step 1 of the 3 steps in the speech licensing concern. Obviously, it wouldn't address promptness, and it wouldn't address prompt judicial review.
I have to ask the government about it, but your concerns with promptness and prompt judicial review depend on understanding the act to displace any other fair use defense. Because you wouldn't need prompt judicial review of the Library of Congress ruling if you retain in your pocket a fair use defense. You're just as well off as you were before the Library of Congress tried to, ease broad categories in terms of promptness and prompt judicial review.
The government doesn't interpret the statute to include a fair use defense at all. So,
Does it interpret it to displace a fair use defense that you'd otherwise have?
well, if the government sues me for copyright infringement and 1201A circumvention, I have a fair use defense in their view for the former, but not for the latter. So however fair my use was, they can still get me if I use DCSS to decrypt my DVDs.
You have a First Amendment defense regardless. They can't take the First Amendment out of the MCA.
To challenge the application
So
of
you'd always have a
1201A.
First Amendment defense.
So to the extent that you're correct that fair use is supported by or is as strong as the First Amendment, then your concerns would seem to rise or fall with the extent to which you're right about that. That wasn't very clear. So you've taken the position that fair use is and should be viewed as a First Amendment right.
Yes, Your
And
Honor,
so
in the context
what
of,
Judge Millett is saying is that you would have a First Amendment defense to.
Or you
a
could try to
digital-
make out a First Amendment
Right,
defense. That's
right.
your plan.
If you are correct that you are engaging in, your client is engaging in fair use or third party engaging in fair use, and that fair use is a First Amendment right, then it doesn't matter whether the Digital Millennium Copyright Act codifies that because it's a constitutional entitlement that would remain.
well, Your Honor, that sounds like saying that we would have to bring an as-applied challenge rather than a facial challenge.
Well, no, or
But-
if somebody tried to prosecute, just as was always the case
Yes.
with any law that to which you might have a First Amendment defense, you could say, no, First Amendment here. And so right?
I could bring that defense. I'm worried about chilling, of course, because, the part of the concern about speech licensing regimes is that they cause people to self-censor in addition to.
It seems like a very odd complaint to bring where maybe the way to clarify my question is, if we read the Digital Millennium Copyright Act's triennial rulemaking as an effort to do some kind of advanced wholesale description of fair use categories, to just ease people's concerns about chilling. And then if you're right that the First Amendment protects fair uses that might not be captured in those categories, to be worried about the Librarian of Congress rulemaking as something that's going to add a chill to someone's experience without those exemptions seems perverse. It seems very unlikely.
It sounds like a well-intentioned provision that nonetheless places a government official in charge of picking winners and losers among speakers.
Other than the tinkering with your car software to deal with exhaust, which I'm not sure where the reading or expression comes in, but what examples or hypotheticals do you have of the Librarian of Congress exercising the discretion that is given by the statute in a way that is chilling?
Well, I mentioned the difference between K through 12 or adult GED teachers and university professors, or the difference between narrative filmmakers and documentary
So,
filmmakers.
If I'm a narrative filmmaker and I'm not given an ex ante categorical exemption, I'm not included within one of the rulemakings, but I still have a First Amendment right by your hypothesis to fair use. How am I disadvantaged?
Because your insurance company, and your production company, and the people who finance you will not agree ex ante that you are clearly allowed to do it. And so your
But if
speech will
we
be chilled.
struck down those categories, the Romanet 1 through 5, if we struck down the Librarian of Congress rulemaking, that would still be the case. It would be that client, the narrative filmmaker, would be in the exact same jeopardy. Maybe I'm wrong about my fair use scope determination. Maybe I'm wrong that this is a First Amendment right. But that would be true with or without the Librarian of Congress provision.
Yes, Your Honor. The problem with the broad prohibition is limiting all speech that people have limiting things that people have the right to do. The problem with the librarian being in charge is that people will try to anticipate the librarian's preferences, try to shade their speech toward what the librarian wants to hear, and that they're subject to content discrimination by the government.
We don't have any examples of content discrimination. I mean, are you saying that the university versus K through 12 is content discrimination?
I am, Your Honor. I wouldn't have a 5th grade course delivered to college students, nor would I display a documentary and describe it as a narrative film.
But that doesn't add chill if you are right about the expressive fair use First Amendment protection.
I agree that the librarian making the decision doesn't add general chill. It subjects me to content discrimination by the government, which will, among other things, lead me to try to speak in ways the government might approve of.
I just want to make clear, your K through 12 teacher, it's not enough to have an overbreadth. If we thought you had alleged an overbreadth challenge to the circumvention provision, how have you alleged an overbreadth challenge to the trafficking provision? Because if the K through 12 teacher cannot get that software you mentioned that they need, and I read our Green decision to say there isn't a First Amendment right there, your case falls apart, right? Unless you have to win, you have to take down trafficking to get anywhere on circumvention. And how does your complaint allege overbreadth as to the trafficking provision, given our decision, or in light of our decision in Green?
Your Honor, the trafficking and circumvention provisions rise and fall separately. It may be that we have not plausibly alleged that there are more cases of trafficking being unconstitutionally forbidden than constitutional.
Okay, so if that falls out, if the trafficking challenge falls out, although I'd like you to tell me if you think you have actually stated a claim there, but let's assume for my question that it falls out. Well, then how many of the people that you list in your complaint, the K through 12 teachers, can independently have the technology to decrypt, circumvent, otherwise access this information if they cannot get anything from, they can't buy anything, they can't get it, they cannot engage themselves in the decryption process?
Well, Your Honor, we allege in the complaint that, for example, the code that protects that the trapezoid cable, the HDMI cable, is publicly available. The Corley case is all about how publicly available, easily available the DVD decryption device is. Blu-ray has similarly been cracked publicly. So I would, as a factual matter, I think the K through 5 teacher can simply decrypt it.
Do they violate anything if are these are available for free, or do they have to pay for them on the internet?
I don't know the answer to that, Your Honor.
If they have to pay for them, are they not involved in trafficking if they buy this stuff off the internet? I could be wrong. I don't know exactly how it's defined, but it seems like a silly
In the Corley
if you
case,
buy it, we just don't let you sell it.
well, in the Corley case itself, it was given away for free. That makes a difference.
Well, there's no allegations of complaint about this. So I'm trying to figure out that I understand like why you say the K-12 teacher, what they want to do, and why you think that would fit within traditional fair use. And maybe you even have an argument or not, but maybe let's assume that that actually would be First Amendment protected speech if they did it. If they don't have the wherewithal without being able to use technology that is criminalized by the anti-trafficking provision, I don't see how your chill problems are gone, and I don't see how you can make a plausible allegation that there's all this speech to be engaged in if they just can't break in to do it.
Your Honor, the entire premise of the 1201 rulemaking, the whole reason why all these people get together every 3 years is because they know it's easy to do. Everybody is circumventing the question, and they have the tools. The triennial rulemaking does not permit
Everyone's already
traffickers.
doing it and they already have the tools, then why are we here?
Because they don't
You
want to
keep telling
risk
me people are
government
chilling and they
prosecution.
can't do it. They don't, exactly. Well, that's my question. If you don't take down the circumvention ban, they're going to have the same risk.
I'm not sure I understand the question, Your Honor.
Well, if I'm assuming, government can certainly tell me if I'm wrong, that at least purchasing something off the internet that is illegally trafficked may itself be unlawful. Assuming at least there's some sort of intent there, right? And if purchasing is, I'm not sure why downloading something that I know is unlawful and stolen isn't also covered by the trafficking ban. So if all the speech you want to allege over here in the circumvention claim can't be accomplished as long as there's a trafficking ban, then there's really nothing to be protected there.
Your Honor, I disagree. Well, one reason is that we allege in
Could
the
be very much
complaint that,
misunderstanding this.
well, we allege in the complaint that these decryption tools can simply be figured out. You know, somebody can reverse engineer within their rights. And
No doubt there are people in this world who can. I promise you, I could not. There's brilliant K through 12 teachers. I had some great ones, but I can't assume, and I'm not going to assume that all of them can do the math on their own to do this. Or at least that there is such a volume of people out there who can do it, that we've got an overbreadth problem. I'm expecting that actually those people are pretty rare. Am I wrong? Can you do
the
it?
people who can actually develop a decryption tool, sure, it
Right.
does sound
I
like they're rare, but
Okay, so
People are
I'm
getting them
assuming
all the
most of the
time.
people that you've identified in your complaint can't do it, either for mathematical ability, resources, time, can't do it. So saying that it can be done out there really isn't much by these incredibly sort of genius-minded people. It doesn't really help here. So now all your people in your, most of your people in your complaint, obviously Mr. Haman can, but the other ones, if they can't do it, if they can't get the technology, there's nothing for us to help them with.
well, they do get the technology. That's the premise of the 1201A rulemaking. The filmmakers do it, as they mentioned in their amicus brief and as alleged in the complaint. There would be no reason to apply for
They
an
do get it
exemption.
Through
It takes a,
exemption, or are you talking, there's no exemption to trafficking. So I'm sorry, that they're getting it off the internet.
well, trafficking has certain requirements. It's not that every single decryption key is a de facto trafficking violation. It would be possible to have a key without having trafficked it. If it was given
Is
to
that normally
people,
how it is? It's pretty hard. I mean, suppose we have some sort of, someone bona fide comes into possession of it, but it's not normally how theft works and people who come into possession of stolen property. I mean, if they know there's a trafficking ban out there, if we're assuming for this purposes your trafficking ban fails, or at least you haven't stated an overbreadth claim,
well,
then, and they know, because you told us they're all going to be chilled by it, so they must know, then what are we protecting?
well, so people go to get an exemption from the circumvention ban and they invest a considerable amount of hours and lawyer time over the course of more than a year to complete the process. There's a hearing. The reason they go through all that bother is because they know that if they get an exemption, they will be able to use it with off-the-shelf technology.
There's technology that does not violate the trafficking ban?
I don't know whether all of the technology violates or doesn't violate the trafficking ban. Obviously, technology itself is not
All
banned.
of this technology, by your hypothesis for the circumvention ban, has to circumvent these protections.
Unless you come up with it yourself.
What's
Well-
the circumvention?
There's no banned technology in the statute. It is banned acts by people. So I don't know, as on the motion to dismiss, I don't know how many of these tools were
The
trafficked or not.
The trafficking ban is putting things out there that have like a primary purpose of circumvention. That's illegal.
Your Honor, I don't know if, I mean, certainly this statute doesn't make DCSS, the decryption key for DVDs, it doesn't make it illegal. It's not illegal to possess it. It's not, but it's illegal to circumvent
it?
without an exception.
Use it.
To use it, it is illegal to use it without an exception
That's my
under
point.
1201A.
Okay, if you get an exemption from the Librarian of Congress, you can use the key,
Yes, Your Honor.
no matter how you got it.
Yes, and I don't think the librarian is aiding and abetting massive law breaking by doing so.
And then, do you have an argument that you've stated an overbreadth claim as to the trafficking provision?
Yes, Your Honor, the previous panel disclaimed jurisdiction over that claim. So I agree that there are fewer examples in our complaint of traffickers than there are of
Have you stated
circumventors.
an overbreadth claim?
Yes, Your Honor,
How?
because the statute,
Which examples, which specific concrete examples in your complaint? Give me your best example of someone you've identified in your complaint and the facts you've provided in your complaint that show me that the trafficking provision only is applied to that person is unconstitutional.
Your Honor, if I may do that on rebuttal, if that works for you.
Sure.
Thank you, Your Honors.
Mr. Springer.
Good morning, Your Honors, and may it please the court. Brian Springer on behalf of the federal government. I'd like to just take a step back and contextualize what we're discussing here. The Digital Millennium Copyright Act provides incentives for copyright owners to make their works readily available in digital form. The compromise that Congress struck in the act was to allow restrictions on access to prevent the massive piracy that would result if consumers could easily create unencrypted digital copies and rapidly disseminate them across the globe at the click of a button. Without the protections that are challenged in this case, manufacturers could mass produce devices that would wipe away access controls on every type of digital content imaginable, and anyone could go to their local Best Buy or Walmart, buy such a device, and use it to create unencrypted copies of all variety of movies, TV shows, music, and ebooks. I think one important thing to do here is to focus on what the Digital Millennium Copyright Act actually prohibits. It is not a restriction on speech at all. It is a restriction on conduct on a particular act, namely the act of circumvention, and then the trafficking in devices to enable that circumvention. So this is different than I think what many of the examples that are being talked about here about restrictions on actual speech. This is not a restriction on speech. It's directed to conduct.
The appellants, they really lean on City of Lakewood and the idea that there was also not a restriction on speech, it was restriction on conduct, but the conduct had such a relationship to speech that the court treated it as a speech restriction. And they're doing the same thing here. And it would actually be really helpful if you could address why that's wrong and whether there's any precedent that helps us see that.
So, Your Honor, I think that Lakewood is a different circumstance because there we're talking about, putting out racks so that you can distribute newspapers. So that has in and of itself sort of an inherent, connection to speech itself, because without having the rack, you couldn't have the newspaper that you're putting out into the world. This is multiple steps away, and I don't think that the other side is disputing that there are many, many examples in which this statute can be applied to a situation that doesn't involve speech at all, whereas that was a situation where sort of every single instance, would be an instance in which you're talking about speech, namely the distribution of newspapers. And here, again, particularly in light of this court's previous decision, there are many, many applications of this act that have nothing to do with speech and that don't implicate First Amendment concerns. We're talking about, again, a restriction on conduct that may have incidental effects on speech. And I think those are the cases that we should be looking to think about this analysis, Your Honor.
How can it not be a restriction on speech when it results in total non-access to that speech?
Sure, I don't actually think that it does turn into a situation where people aren't able. So for example, if somebody buys an ebook, they buy the ebook for the ability to actually read the text of the ebook. And nothing in the Digital Millennium Copyright Act is preventing them from doing that. They're able to do that. What plaintiffs want is to go beyond what these third parties have bargained for and examine the source code or use it in a different format.
They want to engage in fair use.
But Your Honor, I think the right way to think about this is that fair use, it has never been, the Supreme Court has never said that fair use by itself, is sort of a free-floating First Amendment protection. The Supreme Court, whenever it has talked about fair use, it has done so in the context of a specific restriction or regulation of expression. And the Supreme Court has said that Congress has the ability to formulate the fair use doctrine within the particular context of a particular case.
Can you explain why that makes a difference? Just elaborate a little bit on what you're drawing on and why you think that makes a difference. You said that the First Amendment cases that recognize fair use are in the context of regulations of expression. I mean, they would put this together with Lakewood and say, here's regulation of expression.
So, Your Honor, I think the right way to draw it out is, so the Supreme Court's cases, the two kind of most related cases that talk about this are Eldred and Golan, and both of those are copyright cases in which Congress, for example, in one of the cases, I think extended the period in which a copyright would be available. And so in that sort of situation, the Supreme Court explained that that in and of itself might be a regulation of expression and that it would block others from, infringing on the copying of the copyright. And that the First Amendment, the fair use protection is a built-in First Amendment protection to the ability to use that. So we're actually talking about there a regulation of expressive activity. And here we're talking about a regulation of conduct, and any effects are incidental, they're downstream effects on the use of the work. And I think, my colleague on the other side admitted that the act of circumvention itself is not an expressive, that in and of itself is not expressive conduct. And that's what's being regulated by the Digital Millennium Copyright Act.
It's conduct that prohibits speech.
Your Honor, I don't think that's the right way to look at it. What is?
I know you don't, but that's how I look at it. And I don't see how with the precedent that says we're looking not just at whether something is conduct or not, but whether the nexus is so close to expression. And here, the conduct, which is no bypassing, no disabling of these technical protective measures, knocks out any fair use, except for the librarian as gatekeeper provision.
Your Honor, it doesn't knock out any fair use. It leaves the ability for people, for example, if somebody, as I mentioned before, wanted to, bought an ebook and wanted to comment on the book, they're still able to comment on the book. They can read the book, they can, see its contents, and then they can make commentary or reviews or parody or what, any of these things that they want to do, the fair use sort of general things. What plaintiffs want is to go beyond that and to have the ability to use the content in a particular format or to change it or to look at the underlying source code. And that's just not what they bargained for. And it's not a First Amendment problem that they're restricted from doing that, from, having enforced the restrictions that the copyright owner put on the product that is being sold to the plaintiffs or to third, actually here we're talking about third parties, not about the plaintiffs.
Do you think AI affects this at all? Or have you thought about that? I know it isn't in here, but.
So, Your Honor, I don't want to get out ahead of the Copyright Office and the Librarian of Congress. I believe that there are some discussions of AI in the current exemption rulemaking process. So I wouldn't want to get out ahead of exactly how these things interact with each other.
Would AI allow a movie maker to, if he gets the exemption, to copy a perfect copy of a movie so that someone watching it would not know that it wasn't the actual movie that had been made?
So, I don't know as a factual matter if AI would allow someone to do that. I mean, I think you're pointing up exactly what the problems are that the Digital Millennium Copyright is protecting against, is the ability to just create these unencrypted, high quality copies and distribute them around the world.
Can you talk about why? So Supreme Court precedent requires I think a clear nexus or close nexus between conduct and speech. Do you agree that this has that nexus? Or if not, why not?
Your Honor, I don't think that there's that nexus here to the extent that a nexus is required. Again, we're sort of talking about, a restriction on conduct with incidental effects on speech. And I don't think at a minimum the plaintiffs have shown that there's any sort of nexus, especially because there are many situations, for example, just somebody who, rents a movie on Amazon that's available for 24 hours. Without these protections, that person could use a device or by themselves circumvent those protections and just keep the copy of the movie forever. I don't think in that scenario, which is an extremely common scenario, that there would be any First Amendment implications at all. Even if there might be in some kind of, specific small sliver of instances, there might be a practical burden on someone's ability to engage in certain expressive activity.
When I want to read something is not First Amendment protected?
But Your Honor, again, the Digital Millennium Copyright Act doesn't prevent you from reading the material. It prevents the
I'm
thing.
talking about the time limit on, so I said when I read, so when I watch. But normally we would say when you speak or when you read is actually very much First Amendment protected. And I assume the same thing when I watch something.
But again, Your Honor, the Digital Millennium Copyright Act isn't preventing you from watching the movie or reading the book. You're able to do those things. You have to do it within the limits of what,
Right, so I
you
can't
paid
watch
for.
it when, something comes up, so I can't watch it within 24 hours. And so now I have to go pay again.
Your Honor, I think that that's just, these sort of access restrictions are a familiar thing. I mean, I don't think anyone would think that there's a
I
problem
think a
with
familiar thing doesn't mean that it's not a First Amendment thing.
Well, Your Honor, I mean, a good example or something that's akin to this would be a movie theater that bans people from filming a movie while they're in the movie theater. I don't think that anyone would think that there's a First Amendment problem with enforcing that restriction. And that's similar to the sort of access controls
Well, I
that we
think they
have
would say
here.
if I'm filming it so I can then use clips of it to teach my students in 5th grade, there is a First Amendment interest.
But Your Honor, again, it would still be an incidental effect, and I don't think that it would be a First Amendment violation to enforce that restriction.
This is just one thing I struggled with here. When everything seems so fact intensive, how do we know that there's more people who want to pirate and just make money than there are people who want to access this stuff for, I will say, legitimate sort of fair use in that sense term, of the people that they've identified? How do we know? You say incidental, they say there's this tons and tons of people. How do I know?
So, Your Honor, I have two sort of responses to that. The first response is that I think the examples, that this court in the first appeal validated as being, not a First Amendment problem, show the legitimate sweep of the statute. I mean, you can very easily imagine everyday conduct that people engage in, like renting a movie subject to restrictions, borrowing an ebook or an audiobook subject to restrictions, watching a DVD or Blu-ray, using a streaming music site. There's all these kind of everyday activities that people are engaged in that would be lawful applications of the Digital Millennium Copyright Act, even I think on plaintiff's theory. But I would also just point to.
So I get that the DMCA is implicated every day by lots of activities. What I don't understand from your explanation, and I get there's a real risk out there of people destroying the value of a copyright technologically, because once I grab it, I can either release it all over the internet or maybe sell it and make money. So I get the danger to the copyright holder, but what I don't get is for an overbreadth problem, we're supposed to know whether there's more bad stuff being stopped than good stuff being stopped. And that's what I don't have any sense of, and I'm just not even sure how to know that at this very early stage. This just seems like a weird sort of application of overbreadth doctrine because everything seems to be, it's going to be very fact intensive. So how do I know they haven't shown that there's far more good uses that are being stopped than bad ones each day? That those delays are because somebody is learning disabled and can't process the information in a certain way, or can't be exposed to too much stimulation and so has to be exposed to things more slowly. Or the ebook to audiobook conversion is because somebody can't read. I mean, how do I know? Or they want to access the film, they need to slow it down and have some time to show it to their students and make longer clips out than the license is allowing. How do I know what those facts are? And if I don't know, how is this appropriate to decide at the pleading stage?
Sure. I think this exposes one of the flaws in plaintiff's theory here. And again, as you noted, it's their burden to show that the sweep of the statute, that there's a substantial number of illegitimate applications in comparison to the lawful applications. And I think the things you just mentioned about, for example, someone who needs an e-reader or, or is using it sort of in a class. The other side is just assuming that anytime there's a fair use, that means that is protected by the First Amendment. I think that assumption is incorrect. And so they haven't actually shown any applications in which this statute is unconstitutionally applied. Again, because we're talking about, if you look at what is actually restricted and regulated, it's the act of circumvention, which I don't think the other side is disputing, that is non-expressive conduct. And so the only effects that we're talking about here are effects that are downstream effects on someone's ability to engage in certain protected activity.
And that's why you said in your brief that they disputed that this was a relevant comparison. No one would say, that a law prohibiting, skeleton keys that would let you get into every bookstore that's otherwise locked is a First Amendment protected activity or fair use or anything like that, because the act of breaking in isn't. Right?
Yes, Your Honor. I mean, I think that's another example similar to the example of, being able to prohibit movie patrons from filming the movie while they're sitting in the movie theater. Unless there are further questions, we would ask that this court affirm.
Thank you.
Thank you.
Does Mr. Margot have any time? All right, why don't you take 2 minutes?
Thank you, Your Honor.
3 quick points. First, certainly we don't contest that you have no First Amendment right to film the movie in the movie theater or to go into the county jail, as in the Hutchins case, or to go to Cuba. The government's not going to let you.
What
We're talking
you
about.
break into the bookstore, it's the next Harry Potter book is about to be released and you want to get it, break in and get it.
No, of course not, Your Honor. We don't
To
have.
read it. So
we-
how is this different? You're saying all these people want to break in.
Because it's media in their lawful possession. The DVDs on my shelf are just mine. I don't have a contract with anybody. And
What you own is, you've purchased it subject to limitations.
I have not purchased my DVD subject to any limitations
When
from
I
Walmart. Your Honor.
when I decide to watch a movie on Netflix, it says you get it for 48 hours if you pay this price. Do I actually now own that movie and I can do anything I want with it, or am I subject to that 48-hour limitation?
We're not contending that, Your Honor, but we haven't had discovery into the
So if
scope.
there's technology that allowed me to extend that 48-hour period to 72 hours or a week or forever, you're not claiming that's that kind of decryption technology that would allow me to change the time limit on how long I can view my Netflix movie? I don't have any First Amendment or fair use claim to that.
No, I don't think so, Your Honor. We're talking about reading something in your lawful possession and then making fair use copies of it. I would want to mention that the parade
Okay,
of horribles.
and when you get download these ebooks, they don't come with any terms and conditions that you have to click on?
Your Honor, if the government wanted to raise in discovery the idea
No, I'm just
that
asking you. You're the one who has the complaints with the examples. When people download their ebooks, my recollection is I have to click the term and condition agreement. Is that incorrect? Your plaintiffs say that doesn't happen, that in fact, they're told this ebook is yours, you can do with it whatever you like.
that's not alleged in the complaint, Your Honor. Certainly, we don't say that contract remedies against somebody who violated the terms and conditions of an ebook site would violate the First Amendment.
But no, I'm not asking that. What I'm asking is, so if you bought it pursuant to those limitations, you would not then actually possess the right to use it in any other way, even if you have I now have this ebook, I've purchased this ebook. I have the technology here in my house to be able to turn it into audio, but if I click the terms and conditions, I'm assuming the terms and conditions said I cannot manipulate the format. That would not be one of your examples then.
Your Honor, that's a harder case for us, of
Why is
course.
it harder?
It's in your,
I don't possess. I don't possess the
if
right.
you
I
don't
haven't
possess the
purchased
ebook, you
right.
don't possess it.
No. I possess the ebook pursuant to the terms and conditions.
Yes, Your Honor, if the idea is that you don't own the
I
ebook,
own my condo. I don't own a condo, but if I owned a condo pursuant to homeowner association terms and conditions, I own the condo, but I own it with limitations. And I don't understand why this is any different here.
well, obviously what's different here, we're saying, is that you own the media in question and can lawfully access it but for 1201A.
If I own a skeleton key, can I use it to break into bookstores?
If you own the skeleton key, you can break into your own home. Yes, of
Can I use
course.
it? That's not what I said.
No,
The
of course you
question was-
can't break into bookstores.
Right, well, so if you own this, if you own something, there are limitations on all the things that we own and use. And if the copyright holder here has the right to control reproduction. Full stop, right? That is what the copyright is. They have the right to control reproduction of their expression.
But if
And if what your clients wish to do is to use technology to break apart the protections that copyright holder has put in to prevent reproduction of her expression, I don't know how it is any different from breaking into the bookstore to read something.
copyright recognizes a first sale doctrine where if I buy a book from the bookstore and I take it home, I can do with it as I wish. The copyright holder doesn't have a permanent dead
Can I
hand control over.
Xerox it and sell it on the marketplace?
No, because that's one of the exclusive rights in
Exactly.
106.
Exactly.
And that's
Well, okay, well, if they have, they've said, what, I've given this to you, but I have the exclusive right to, I'm selling this in the marketplace, but of course you cannot reproduce it and sell it for your own purposes. Then that's what all your clients want to do. They want to reproduce some part of this for their own purposes.
Your Honor,
They say maybe it's fair use or not, but they want to reproduce the copyright holder's expression for their own purposes. And that thereby denies the copyright holder control over the reproduction.
Your Honor, copyright holders have always had the limited monopoly allowed by copyright subject to people's ability to dispose of their copies as they wish and for people to be able to copyright
Not
facts.
as they wish, subject to certain limitations.
Yes, Your Honor, subject to limitations on
Copyright
copying that is
limitations.
not fair use and that copies protectable elements
So
of
why
the
isn't
work.
this saying this is a copyright limitation? This is a limitation. Congress has a right Congress has given to the copyright holder to effectuate their actually pre-existing control over their own expression in a modern era.
Because it makes no allowance for fair use or the idea expression distinction, the accommodations between copyright and the First
Can
Amendment.
Congress change the scope of fair use?
I don't know, Your Honor, that hasn't come up. The codification in the 76 Act is close to the common law version. I'm not saying that Congress has no scope to change any part of fair
Your
use.
fulsome opinion said that abridgment of works was fair use. The original copyright only protected until you actually market something. And then Congress, of course, came along later, I think in 1909, and said abridgment is not fair use. That's part of the copyright holder's rights. So Congress can actually narrow fair use.
Your Honor, I think that's correct. It's just not applicable here because here Congress has eliminated fair use, which is not permissible under Eldred and Golan.
So how do we know that the elimination's here? As long as you always have the right to assert that a particular application is unconstitutional under the First Amendment, how do we know? And it hasn't eliminated it. You have the librarian process. Judge Pillard said you can try and argue it as a defense. It's always a defense.
Your Honor, I think that courts would be hesitant to find an act of Congress unconstitutional in a criminal case as far as forward-looking, wanting to express yourself. I wouldn't
Courts
advise.
do it all the time in speech. A lot of the First Amendment precedent from the Supreme Court involves criminal prosecutions for speech. I don't know what you mean courts wouldn't, if someone raised a First Amendment defense, courts wouldn't adjudicate that in a criminal case. That was Stevens.
Your Honor, yes, I agree that First Amendment defense exists. I just don't think it's sufficient to salvage the constitutionality with respect to the overbreadth claim. Very briefly, you asked about trafficking. I would say that the first panel does seem to believe that Bunny's device, the net VCR, falls on the Grokster side of the line, not the Sony side of the line, the kind of thing that it thinks would probably facilitate secondary infringement.
So we don't have a plaintiff here that has an anti-trafficking claim?
There
A named
is
plaintiff, right?
Professor Green, there are no as-applied challenges left in the case.
No, is there a plaintiff that has, so there's, all right, so there's no as-applied ones by Mr.
Professor,
Bond. What activity does he want to engage in that involves trafficking that isn't covered by our Green decision?
Professor Green?
Oh, sorry, no, Professor Wong.
I'm not aware of anything alleged. There's nothing alleged in the complaint beyond the net VCR. I would caution, however, that the next person who tries to traffic might be developing a specific tool designed for fair use for repair shops to be able to access Toyota motors.
Is there an allegation like that in the complaint?
There is no allegation of specific fair use oriented trafficking of carefully crafted tools like that. No. Thank you, Your Honor.
Right, thank you.
This honorable court has granted your, you say make that in.